Well, guys, good evening. Welcome back to the channel for day 17's recap in State versus Richard Allen. It was a half day today. So, for the first time, I might be able to stick with my commitment to not make this a super long stream. And part of the reason why that is because even the time that we did spend in the courtroom today, very little of it was really substantively accessible to the public. And this is because today's focus was on the defense playing some video segments, a variety of different clips from different dates showing Richard Allen's conditions of confinement while he was at the Westville Correctional Facility. Before the hearing got started, Mr. Rosie stated that it was a request of the defense that the videos not be exhibited to the public gallery, and that this was because the videos contained some very explicit details, and that it was essentially for the privacy and dignity of all the participants, but certainly Mr. Allen. So the screen that the videos are played on, it was set up in the courtroom and angled at a way that was intended to prevent the gallery from being able to get a glimpse of the video while allowing the jury to be able to see it. Well, that left us with really nothing else to watch but to watch the jury watch the video. And so that's what I did today. And I have a lot of notes. I have a lot of notes about that, a lot of notes about what I saw. And so that's what I'll be talking about with you, the indications of just reactions from the jury to what it was that they were seeing on the screen. We did hear from one witness today. That was the head of the Indiana State Police. Trying to remember the actual title that he had. I think he's the superintendent, Doug Carter. Doug Carter, I'm understand, is kind of had been the face of the investigation during a lot of the process before Mr. Allen was arrested. He would communicate with the press and be a conduit for information about how the investigation was going. And he was very short in his testimony. Essentially, all that we elicited from him was that it was his decision for the FBI to leave the case back in August of 2021. So previously heard that FBI had been booted off the case, and some folks who weren't in the authority position, more underlings in the process, indicated they'd be surprised if that was the case. Well, the head of the Indiana State Police confirmed it today. It was his decision for the FBI to leave. And as he asked them to leave, he also asked for them to return all of their investigative materials. Now, we don't know if the FBI complied with that. The FBI, when it's involved in an investigation, is going to have its own responsibilities with respect to record keeping and maintaining that type of thing. So we know that he asked. We don't know if he got what he asked for. So with that, let's go ahead and get into the details. Also, because of how today transpired, we didn't have nearly as many sidebars, but we did have some. And because I've learned, I'm now starting to keep my running tab of the sidebar length. It wasn't bad today. We had 3 of them total. They were about 3 minutes each, so only about 9 minutes total sidebars in about 3 hours of proceedings, because we were done by about noon today. I do apologize, by the way, for being a couple minutes late getting on here, but I took the opportunity to nap. I had high ambitions for today that just did not come through. It was a beautiful day too. It's like so unfortunate. It would have been such a perfect day to go outside, but no, I napped. And so had a little bit of a scramble getting myself and everything else together, ready for this recap. So as always, we will start with the Mr. Rosie style watch. Today, he was in a black suit and a shirt that it was difficult to tell under the lighting whether it was a white shirt or a very, very light, subtle blue shirt. And his tie was a blue color that I think is best described as cornflower. It's just a little bit on the spectrum between blue and purple. When I actually got a closer look, I saw that it was a square pattern, alternating colored squares, and so it's actually very tiny little bits of darker blue and white. But at the distance, it reads as this cornflower type of tone. So I do like me a nice cornflower. I thought just once again, lovely color. He's got a very unique eye for colors that just stand out, are not conventional, not your primary colors, not your bright, vivid things, just unique and very eye-catching. So we did start today a little bit later than normal. The start time for court is normally at 9 o'clock. They have been pretty sharp about getting things started. And so it was noticeable today when the clock was ticking and nothing was happening. We were continuing to wait. So it was about 9:15 before the court ultimately came out and is brought into session. So as they're doing this, we can see that they are, moving the TV into an angle where we, the audience, are not going to be able to see it. We have a kind of recap of what the status is with this evidence, because as you will recall from yesterday, there was a lot of back and forth and just modifications that were requested, ordered, needed to be made to these videos before they were going to be able to be played. Some of them required to be removed. The dates considered to be not relevant. Others were associated with audio recording, which is not admissible because it is hearsay when the defendant offers his own out of court testimony. So there is very little to no avenue for Mr. Allen himself to be able to get that type of audio recording admitted. And I want to point out that this is the case even if he does testify. His testifying doesn't alter whether it's hearsay or not. Hearsay is, as I've said, it's an out-of-court statement that's offered to prove the truth of what it says. So I have had some questions. Obviously, I don't know what this content is. I haven't heard it, and so you can't evaluate it without knowing specifically the substance of it. But it does seem to me that it's not being offered for the truth of what it says. It's being offered to show Richard Allen's mental state at the time, his condition. And that type of information. I mean, just kind of as an example, if he is ranting psychotically about delusions that he's having, well, nobody is saying, the defense certainly isn't saying the delusions he's expressing are true. So I have a lot of questions about the hearsay rule being applied to these particular statements, but that is what the rule is. That's what the ruling has been. So that is what we are stuck with. And that means that we in the audience weren't able to hear anything as well. But the jury was also not able to hear whatever it was that was recorded sound-wise on the camcorder system, which is what they are referring to as a transport camera. So essentially, anytime Mr. Allen was removed from his cell in Westville, whether it's taken down the hall, taken to medical, taken to rec, anything like that, there is a prison guard who has a camcorder and is video recording the entire thing. So that's the source of this information. These videos that were shown to the jury today is the camcorder video, but without the associated audio recordings. So when we came back in, they acknowledged that previously the defendant's Exhibit XX, which was the thumb drive containing the videos they wanted to introduce, that had been admitted over the state's objection. That consisted of in-cell video as well as the camcorder video that we've talked about. The defense also offered 2 master sheets, which were essentially just guides that listed what videos were being watched, the video file name, the time of the video, and I think to the extent that they had it, the date that the video was taken. So we reestablished that the master sheet that's associated with the in-cell video, that was originally exhibit number ZZ. The defense chose not to offer it at this time. It sounded like because they didn't play the in-cell video today, they have not modified that particular exhibit to eliminate the videos that aren't going to be included on it anymore. So they have, more work that they have to do to finalize that part of their evidence before it can be introduced. So they're probably doing that, over the weekend, as much weekend as we have, with half days on Saturday. But they did admit the master sheet, exhibit YY, which was the same thing, but with respect to the camcorder video that was played to the jury today. So the jury did have that sheet that was published to them. They were able to use that to follow along, assist with their note taking and so forth. So Mr. Rosie addressed the court and indicated that they had a conversation in chambers, just putting this on the record, what happened. There was a conversation with him, Mr. McClelland, and the judge back in chambers, where he said the video contains some explicit scenes and that he has some concerns about that, and that out of respect for the individuals involved, including the families and Mr. Allen and everybody else, that material not be aired publicly. And the judge stated that they had moved the TV recorder to the center where only the jury can see it. So she's making her record of what the court's actions were and what the court's intentions were. The state indicated that they were objecting to anything that was beyond video number 1. Never stated the specific basis for this objection, but it became clear later on, and I'll mention it when it came up, that the state was objecting at least on the argument that the evidence was cumulative, that this was essentially repetitive, wasn't adding anything to what the jury was able to observe from the very first video. I'm very skeptical of this particular objection as well. Again, not seeing the videos for ourselves, it's difficult to evaluate the content of them. But the entire purpose of them was to show on different dates how Mr. Allen was presenting, what the conditions were, and in this particular circumstance, likely how he was being treated by prison guards as well, like the actual interactions with some of these DOC corrections officers. The judge then stated that if she gets to the point, because she's already overruled this objection, she says if they get to the point where she agrees with the state, then we would have a sidebar on that. So I think holding open the possibility that she might change her mind on it, but at least over the course of today, that did not happen. She also stated that the state had apparently provided some information, the exact nature of which was not entirely clear, but she appreciated the state providing that information to the defense because they did not have to do it. It was part of their work product, which is normally confidential. It's one of the privileges you have with an attorney. You have attorney-client privilege. You also have work product privilege. And it's just because the products of your preparation, your analysis, those tend to give insight into your thought processes and ideas and maybe reveal some of the confidential information that you have access to. So in general, work product is protected, is confidential, just like communications with an attorney are confidential. She said, so she appreciates that made it easier for the defense to be able to present this essentially in a way that I think was coherent and reliable. What impression I was getting was that they had more detailed information about the dates of the videos in question. And they provided that to the defense so that the defense was then able to incorporate that and make sure that they're showing things in the right order, and that everybody has a full understanding, and it's not being presented in a way that is potentially misleading or incorrect. So at this point, the jury is brought into the courtroom. Once again, they have been allowed access to their phones to have contact with the outside world and check their emails. So they're questioned about, have they reviewed any media sources? Has anybody attempted to speak to them about the case? So forth and so far. All of the jurors continue to indicate that they are abiding by the court's orders there. Mr. Rosie recalled Max Baker, his legal assistant, who has been primarily responsible for compiling these videos together. And so we reiterated that they had received a list. Oh, this I think is explaining how the information that they got from the state that assisted them in being able to re-prepare their presentation. So they received a list from the state that organized the videos with dates for them, and that those particular videos that were on the camcorder were not time-stamped. And so from that, they were able to verify which date each of these individual videos came from. So this has now introduced a new thumb drive, Exhibit DDD. These were videos from April, May, and June, and they were all consisting of these movement videos, the ones that are taken from the camcorder. They also, as I indicated, introduced the master list for this particular set of videos. That was Exhibit EEE. And it showed the file name, the date. The first one was only able to be identified as between April 1st and April 13th, sometime in that time frame. But the rest of them had a specific date available for when they were taken. He was also testified that he was able to get some sense of chronology because of the file numbers, the fact that these videos appear to have been all taken from the same camcorder, and he had not received any information otherwise that there were multiple camcorders involved. Then the file numbers are assigned chronologically as well. They advance in sequence. And so you could infer if a file number was, his example was number 264, you would know that file was recorded in time before a file that had number 973 on it. At this point, Mr. Leland continues to restates his objection. He's requesting a continuing objection, basically, so that he doesn't have to get up and restate it every single time a new video is played. The judge grants the continuing objection, so we know that he doesn't want the video played, and that record is clear. And at this point, the videos are now published to the jury. So this jury, I want to give you some background. They have been very, very deadpan throughout this entire case so far, and that is very normal. They have a duty, they have a responsibility. Most jurors take that duty very seriously, and so they don't want to interfere with that. They're aware that there's an audience out here and that people are watching, and it would be contrary to the solemnity of what they're being asked to do if they were to, make it kind of like a performance or make themselves part of the show. Like the jury is not the show. The evidence is the show, and so most jurors in general they tend to respect that and maintain pretty good poker faces. And this jury has certainly abided by that so far. And so a lot of what I'm going to talk to you about as far as reactions go, these are not like large intentional types of responses. These are things that I'm observing by watching them that appear to be unconscious. These are reactions that the jury is manifesting through their body behavior, their expressions, things like that they're not necessarily trying to do or doing on purpose. They just happen. And so you'll see what I mean as we get into some of the details. So as the videos are starting to be played, I do notice some of the jurors right away looking over in the direction of where Kathy has been sitting in the courtroom. Kathy was not there today, just like when they tried to admit this yesterday. Kathy left before this like once that thumb drive had been admitted into evidence, before it became clear that there was going to be issues with actually playing it to the jury. Once it was admitted into evidence, she left the courtroom. It's very clear that Kathy doesn't want to see this. She doesn't want to be exposed to it. She may not want to see, Rick having to see the jury watch this stuff. We've heard a lot of details about just how he was in prison during this time period from the doctor's notes. So we can already anticipate that there's some stuff in here that's pretty grim. And, as Mr. Rosie had indicated, pretty explicit. Heard about him, not wearing his clothing, masturbating. I mean, just, eating his feces, things that are not real dignified, So a couple of the jurors were looking over in this direction where Kathy has historically been seated, but she was not there. So as the first few videos are playing, we see the jury is pretty deadpan, but very attentive. The jury is very attentive to these videos throughout the entire process. As we get into the second video, I start to notice jurors kind of checking against the master sheet, and a couple of them now have started to lean forward. So just indications there of attentiveness to what it is that they're watching. They are leaned forward in a focused type of pose towards the audio screen. By the time video number 3 starts playing, these videos are all, by the way, of varying lengths. I didn't write the time lengths down. Initially, when they started playing the videos, they didn't tell us specifically what dates they were, the time of day that it was taken. As the videos began to progress, they were introduced with more of that information. So once that became available, I did start taking it down as it was provided and as I was kind of able to catch it. But these initial ones, we didn't have that information. And so the length of the videos was variable throughout the whole process. Some of them were very short, some of them were very long. And when I say very long, I mean like in the ballpark of maybe 10 minutes or so. Some of them a lot shorter, couple minutes. The first few, as I recall, are pretty short. They're not really extensive length. By the time we get to video number 3, I'm definitely noticing this jury is very attentive. They are very deadpan, very poker faced. I did notice one of the jurors who I had noticed during the jury selection just appears to be a very bubbly type of personality, happy, smiling, interacting, responsive to the attorneys and their questions. It's really engaged and comes across as just a very positive type of person. I observed the longest face. Very long face on this jury. I saw this particular juror make a kind of swallowing motions and take a very deep sigh. So this was my first indication that these videos are having some impact. The jurors are paying attention to this, and they're beginning to have some reactions to this that would tend to suggest to me that these videos are hard to watch. These are not necessarily, these are not necessarily things that they're enjoying being exposed to. So again, the jurors are extremely attentive, and many of them are now taking notes as they're watching the videos. They are looking down at their pads and they're taking notes. A lot of times when the jurors are taking notes, you see all of them at the same time. There's a congruence in whatever it is that they're watching, that they they all react to, and they take those notes in simultaneously. So video number 4 was the first one that was dated. That one was dated April the 13th of 2023. If there was a time given for that one, I didn't note it. So April 13th this is about the time when they're starting to talk about the Haldol, right? So we already know we're in feces land in this particular time frame. So one of the jurors I notice is starting to make gestures that suggest some discomfort. Physical discomfort starts to become a theme the more that we go on here. And so I'm noticing this juror doing these kind of neck stretching and a lot of shoulder kind of things that just kind of from a subconscious level suggest trying to get more comfortable, feeling uncomfortable, and trying to resolve that. One of the jurors in the back, who has so far I have not seen really do much of anything at all. Very, very unresponsive. This juror has begun to rest his hand on his face, and kind of, holding like over his face, like this. A lot of jurors begin to have this hand-face contact, hands over mouths, hands in faces, a lot of touching of faces. Video number 5 was taken on April 17th at 2023 at 9:31 in the morning. So now a juror up at the top, I'm noticing, is still starting to look back now and look over in this area of where Kathy has historically been seated. There are a number of people sitting in the reserved seats for the defense, but not Kathy. So just continuing to check in on that general area, and now continuing to make these gestures of comfort. I also saw some rubbing of the face and some lip tightening. I began to see lip tightening throughout this process. And so when I'm describing lip tightening, what I mean is something like that. Just a tucking in of the lips, pulling back of the cheeks. This is like a tension sort of expression. If you make that face yourself, you can feel like it's tight. It is a tense type of pose. So I'm starting to pick up on perhaps a little bit of anxiety among the jurors who are watching this. Video number 6 is also on April 17th of 2023. This one was taken at 11:59 a.m. The juror who I have not previously seen do anything, who is holding the face in the hand, I now see is starting to rub the back of the neck. And the juror who has been doing this, this kind of shoulder shrugging, head movement, stretching type of thing, is continuing to do that, continuing to look over in the direction of where Kathy was. And now I'm starting to see a lot of people do these facial kinds of comforting gestures, just like rubbing, touching, little bit of contact, throat, cheeks, chin, very occasionally forehead, but more commonly this type of gesture. Video number 7 was taken on April 17th as well. So we have 3 videos from April 17th. This one was taken at 5:22 p.m. An extra, like a new juror now who I haven't had, notes on before. And by the way, I'm not identifying, these people very specifically. So this juror I see beginning to make mouth movements. And so I see a variety of mouth movements that different jurors make. And when I'm describing that, what I mean is it almost looks like chewing types of gestures. It's It's like shifting, like sometimes it might be leading up to a swallow, but just the mouth now is reacting. So I'm beginning to see that in one of the jurors. So I see these mouth movements, and then the mouth is slightly open while watching. The video is playing, and the mouth is slightly agape, and then there's like the chewing motion. So just that kind of thing. Involuntary doesn't appear to be that this type of thing is intentional. It's just how the body is reacting to what it is that they're watching. This video was one of the longer ones, and I say that because I know that because I have a long list of observations that I made from different jurors. One of the jurors who I haven't seen previously, in making any kind of overt, signal of any, responsiveness, I began to see what I referred to as a slight rocking. And when I'm saying a slight rocking, I mean a movement in the seat that you can see. You can see that there is movement, there is repetitive movement, and this is a very tense thing. If you do this, you can kind of feel it coming all the way from your feet, like you're probably, using your feet to push against the floor a little bit, and you're just kind of rocking yourself very, very slightly. This is extreme tension. So I noticed this. At this point, I did make a note of the judge also watching these videos intently from that looking down the nose pose that she often assumes in court, which is not, by the way, I want to be clear, it does not appear to me that this is to be able to see through the glasses. I know sometimes, if you got glasses, you got to kind of adjust to make sure that you're seeing through the right part of the lens. Because at different points in time, I see her watching the video and she's watching it in a normal, normal head forward position pose. She interacts with people in a normal, reads things in kind of a normal pose. So this head back, looking down nose is something that doesn't appear to relate to the need for any greater visibility. But so I did notice the judge at that particular point in time. Another juror who has been very deadpan throughout, haven't described any reactions before. At this point, I start to see the lip tightening. This particular juror, when this juror would make a face tightening gesture, I described it. I'm not intending to be like anything. I just described, for descriptive purposes, I called it beaker. If you're familiar with, the Muppets and the I forget what Beaker is actually even from, but one of the puppets, and Beaker has like an exaggerated upside down, a frown, like an exaggerated frown. And so when this particular juror would do the lip tightening gesture, it would be associated with this like very, very distinctive frown. A juror who has not previously reacted has been taking lots of notes and being very attentive, is now watching with the mouth slightly open. One of the jurors is now really looking around the entire audience, continuing to look back in this direction of the audience. But then also, so Mr. McClelland has brought a chair over and he is sitting right next to the jury box to put himself in a position where he's able to watch the video as it's being played, which is perfectly proper. And, yes, you need to do that. The attorneys need to see what's being played as well. But so he's been down here at the far end of the jury box and really has garnered no attention. Well, this juror is now starting to look at the back of Mr. McClelland's head. Another juror turning to look over in the direction of where Kathy has historically been sitting. I then see this juror begin to blink a lot and exhaled, made a blowing motion through pursed lips. And so I'm going to demonstrate this as like, that's what I mean. I see the juror with the upside down frown, the frown, lip tightening, making that gesture again. At this point, I see that Mr. McLeland is now doing the rocking, doing the very, very subtle, just enough that you can see the whole body moving. I mean, because you can see the background and you can see, when I do this, you can see my head moving against the background. Mr. McLeland is now doing this. He's sitting forward in his chair, and he's like this. So now he is very tense. His feet are interacting with the ground, and that tension is showing as well. The juror, one of the jurors I've spoken of before, is now watching with the mouth open, breathes, takes a very visible, see the chest move, breathe, deep sigh, swallows, and makes a lot of these, chewing, kind of lip moving kinds of mouth movements. And then starts to rest the hand on the cheek. This particular juror has had some hand-to-face contact before when watching things, but has now changed to a very new pose that I haven't seen, which is directly on the cheek. And one thing I notice is that the index finger and the middle finger are cupping the ear. And so this looked like the possibility as well of potentially being a self-comforting type of pose, a little mini hug of the ear that is being displayed. One of the jurors, the juror who has been expressing this discomfort, I see now make a chin out type of movement, bring the glasses down to make a note, put the glasses back up, lips tighten, and then do one of those shoulder shrugs. I see the juror who has seemed most affected by this video throughout has shown the most reaction with the sighs, the swallows, the type of expression. This juror now swallows, blinks rapidly, and watches the video. And the eyes are not no longer wide and alert. The eyes are starting to look. The eyes are starting to look like collapsed, almost like when you are tired, when you are fatigued, and your eyes just kind of start to get heavy. That's how his eyes are beginning to look at this point. Then there's an eyebrow raise from this juror, and then a note that's taken. Another juror during this is making mouth movements. This juror has not previously made mouth movements so far in the course of being able to watch these observations. A lot of reactions to this particular video on the 17th. Next video, number 8, was from April the 18th of 2022. It was somewhere in the ballpark of 2 p.m. I didn't get the specific time. When this video starts, now several of the jurors are adjusting. They're sitting, they're adjusting in their chairs. They are trying to find a more comfortable position to be able to take this in. I see the juror do the lip tightening with the frown. I see another juror who hasn't, I've talked about already, but hasn't had a lot of responses throughout the course of the case. Sigh, look down and take a note. I see a juror who this is the first reaction I've seen from this juror, not just throughout these videos, but also throughout the entire trial. This juror is now starting to play with her hair and make some adjustments to her clothing. These are all just small things. Like, there's not really, you can't say what somebody is thinking from these things, but you can just notice that these are reactions that they're having, that they're engaging in. This is a novel reaction because this jury hasn't done any of this throughout the course of the trial. This juror has sat there pretty straight, pretty still, taking notes from time to time, but not otherwise showing a lot of physical reaction to anything. So this is notable. This juror is starting to show physical reaction to what is being played on the screen. The juror who tightens the lips into the frown, it is now so pronounced, I can't even mimic it. Like my mouth doesn't work like that. But they are very tucked, very frown while watching this video. The juror who has been the most responsive to this so far makes some mouth movements, opens the mouth, then licks his lips, and then the eyes narrow with the eyebrows raised. So it's kind of a like a combination of sort of things that are happening with this expression. Like if I try to make it, it's sort of difficult. Like normally when you raise your eyebrows, your eyes get big. So it's almost like there's a conflict between what's being expressed through this expression. Try it. It's hard to do to narrow your eyes and raise your eyebrows at the same time. This is like it's an extreme, I think, type of expression. Just because it's so hard, it seems like it reflects the type of expression you just don't make, in every day. It's not relaxed at all. Like it's very tense, and like I said, kind of conflicted. Ms. Auger, at this point, she's been standing in the back corner behind the jury. She's been observing these videos for the defense team. And so she is very, they're all, nobody is indecorous in any way at all. But at this point, I see Ms. Auger looks down and she looks away. She looks towards the audience. And then when she's ready to look up again, she shifts her posture and crosses her arms. One of the jurors now goes in, does a very, there have been previously glances over into the direction of where Kathy has historically been seated, but they're not typically very long. They just kind of look in that direction. It's like a check-in, kind of look over in that direction and then look back. This one is now a long look that's like a scan of the entire line of the folks who are sitting in those reserved seats. While doing this, the juror is making some mouth movements and tightening the lips. I see another one of the jurors at the same time looking away and looking out at the audience, really scanning the audience as a whole. Two of the jurors who are sitting next to each other, they communicate something to each other. They turn to each other. Their mouths move very subtly, and there's a nod, a little bit of a nod at each other before they look back. And then one of the jurors turns and looks in the direction of where Kathy had been seated. I see two of the jurors at this point doing facial touching their faces, stroking, having that type of contact. One of the jurors has resumed this pose of, the fingers on the lips, fingers kind of over the mouth, watching the video in that type of pose. See one of the jurors do a pursed lip expression, so more of a like that type of expression, and then chewing types of gestures, and then a shrug, and then a deep sigh, and then looking out at the audience while this is happening. The next video is from April the 21st at 2023. This one is from 9:41 a.m. The juror with the upside down, the severe frown is in that expression. Juror with the hand over the mouth reaches back to rub the throat. These are not like scratching, like I got an itch, or something like that. These are very soft, almost like we're stroking ourselves. We need some comfort type of motion. And then back to the hand over the mouth. One of the jurors who has not been particularly expressive now stroking the hair, not, combing it, not fixing it, stroking the hair. I see Ms. Auger at this point looking towards the back of the courtroom. The back of the courtroom today is not the crowd that we have seen in other days where there's a lot of people, cop looking and lawyer looking in the back of the courtroom. This is not that day. This is a normal day. And so on the normal day, the people in the back of the courtroom are among the guards. So it looks like Ms. Auger is looking back in the direction of the guards, and she's watching them for a period of time while the video is being played. Juror making a chewing and swallowing motion. Now another juror has placed their hand over their mouth. This juror then looks away from the screen, looks over at the audience, and then looks down at their neighbor before checking back in. This is the bubbly juror. This is the one who was just so responsive and interactive during the voir dire. Has now looked away, looking out at the audience, looking like at her neighbor, like at the neighbor's eyes while the neighbor is watching. And now another juror is making a mouth movement and then turns to look at the clock in the courtroom. So just noticeable, checking in on like the time, Don't know what that means. Of course, we don't know what that means. We can't mind read. But, when you're looking at the time, you're typically wanting to know what time it is. And that's because you want to know how much time is elapsed, or you want to know how much time there's going to be, before there's something that you can anticipate happening. Next video is from April the 28th. It's at 8:56 p.m. Now, at this point, the juror who's been most responsive, again, now watching with the mouth slightly open, and now it starts opening and closing. There's a licking of the lips, a blink, and now this juror does a head shake and is making mouth movements while head shaking. Several of the jurors now are touching their faces. There's a yawn from one of the jurors in the back. Not like inattentive, but a yawn. Now the same juror has got the hand over the mouth and is shaking the head again, and then does a deep swallow. Then this juror drops their face away and blinks several times, like slow, not like rapid, but drops the face and makes long, slow blinks. Before, looking back up at the video, then looks down, mouth opens, and takes a note. More shaking the head, moving the hand then over the mouth. A second juror now looks down and is looking at the back of Mr. McClelland's head. I see another one of the juror who had been doing the slight rocking that I've been referring to is now doing that again. So there's a period of the slight rocking. I then see the juror who has been most reactive wipe the right eye while making some mouth movements. I see the juror who has been very unresponsive throughout the entire course of the trial, who just kind of started touching her hair and adjusting her clothing. This juror is now breathing very deep, and this juror has crossed her arms, and this juror starts now looking away from the screen down towards the direction of what could either be the prosecution's table or it could be where Mr. Allen is sitting. Mr. Allen sits at the very far left end of the defense table. And the way that the courtroom is configured, it puts him quite close to the prosecution team and their side of things. So you can't really tell who is being looked at when there's folks looking at that direction. But you can just, those are basically the options of where that glance is being directed. One of the jurors in the back, the one who had yawned, is watching and now looks back, looks down, looks back at the screen, and is holding the notebook that they used to take notes, is now holding that notebook over his mouth. This is a new gesture, hasn't made that before. I now see the juror who's been doing the slight rocking in the chair. This juror now, very noticeably, this is not a subconscious one. This is about the only movement I see during this entire process, that this is deliberate. This juror leans very far forward in the seat and turns and looks down the row directly at Mr. McClelland. And she gives a very long look before coming back to the screen. When she gets back, she takes a deep sigh and is making her mouth working movements, and then begins to stroke her lower face. These types of gestures. The juror who has been the most expressive, holding the hand over their mouth, gives what looks like it's a slight yawn, but it can also be a bit of just a rapid inhale, like almost like a gasp. It's hard to tell exactly what this expression is. It doesn't extend into like a full, kind of yawn. It's very small. And so it looks like it's not like a dramatic intake of breath, like, like you might get from a startle or something like that. It wasn't a startle, but it just kind of inhale. Another juror now stroking their chin. And the juror who's been most expressive is now takes a deep sigh and is now leaning far over to the right to watch this, like a collapsed posture, like really, really collapsed, no longer sitting upright, no longer leaning forward, collapsed over to the right side. This juror is then stroking his chin while watching this. One of the jurors up top, who's been doing the shrugging and the head movements, now starts adjusting his collar. At this point, Mr. Rosie asks if we can take a recess from the watching of these videos, take a break, take the witness who's the defense has on board, and then get back to the videos after the witness testifies. And so the juror who's been collapsed over to the side, I'm going to kind of lean back to show. Very large rolling type of motion to come back like forward and then up. So the judge allows that, and we go ahead and take the break, and the jury, jury processes out of the courtroom, and we have our morning recess. While we are coming back from the recess before the jury comes in, the judge will always ask the parties if they are ready to resume. And at this point, I see that Mr. McClelland is now making some of those chewing types of motions with his mouth. So we had the break to take the testimony of Doug Carter. It was Mr. Baldwin who handled that examination. Like I said, there really was not much to it, but I'll go over the details that I took down. So he testified he's a superintendent of the Indiana State Police. He's been in that role for 20 years. His role in the Abby and Libby investigation was what he described as a support role. He's not a boots on the ground guy. He said that there were dozens of different law enforcement agencies involved. When asked to give examples, he said he doesn't have a list off the top of his head, but just to, ask for just a few that you can think of. He said just about every contiguous county, as well as the ATF, the FBI, the U.S. Marshals, a lot of manpower involved in this particular case. So he agreed that there was a time when the FBI had been assisting in the case, and then they were no longer involved in the case. And then that was probably 2021 that they were no longer participating. There's a I noticed that the juror who has been so reactive to the videos is still, during this testimony, is still sighing and kind of opening and closing the mouth, looking over towards the side of the audience where Kathy is normally seated, and he's tapping his hand on his knee. So like a tap, 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 tap type of motion. I see another one of the jurors looking out at the audience while this testimony is going on. So we established the approximate time frame from the deposition of this witness for when the FBI left as being August of 2022. And Mr. Baldwin then asked, did you ask them to do anything when they left the scene? Basically, when they got out, was there anything that you asked them to do? Mr. McLeland asks at this point to approach. They have their short sidebars. I've indicated these have been short. They're all about 3 minutes each. And when they come back, Mr. Baldwin is allowed to ask his question. He asked, was it this witness's decision for the FBI to leave? And he said yes. So it was his decision. It was not the FBI's decision. It was his. Indiana State Police kicked the FBI off of the investigation. And when he did that, he also asked them to return all of their investigative documents in their possession. And that was the information from this witness. Mr. McLeland did not ask any questions of him. He simply asked if the witness was relieved from his subpoena. And Mr. Baldwin said that yes, he was. So he's not going to be subject from recall. This is all anybody's going to get from him. This is it. He, the head of the Indiana State Police, asked the FBI to leave the investigation in August 2021, and it was then approximately a little over a year later that Richard Allen is arrested. After the witness, the video screen is set back up. Mr. Max Baker is recalled to the stand. Mr. McLeland has he has an objection, but he is not using his confident, assertive outside voice that he has been using throughout the course of this trial. His voice is now extremely subdued. Of everybody in the courtroom, Mr. McLeland is the most, there's a little bit of theatricality to his projection of his voice, but he's certainly the easiest one to hear. And I don't want to blow up the mic, so I'm going to get back a little bit just to kind of give an example. Ladies and gentlemen of the jury, it's very loud, very projected. Not this time. Not this time. He states in his very low, subdued voice, just please note our continuing objection to this evidence. I would note that we're at about 2 hours long now that this video has been played. Yeah, we're at about 2 hours of video so far, and there's still more. Judge has not apparently accepted yet that there's anything presumably cumulative about that, but that's the comment that clued me in. Oh, he's just saying this is each independent video is not helpful. That this is just it's just we're, I guess, watching the same thing over and over and over again. It does not seem like that to me, just given how the jury's reactions have been they've been evolving. They're not giving consistent responses. They are showing, different reactions and kind of more extreme reactions as these videos have gone on. So I don't know what's on him, but it's not convinced Judge Gold that this is cumulative and that there should be no more of the video played. Video number 11 is played. It's short. After the break, the jury has resumed its deadpan. Like the jury has kind of, gotten back to center, as they say in yoga, bring it back to center. And so they are back in very deadpan, but very attentive expressions. So the first couple videos we watch, there's not much reaction. The only thing that I caught was during video 11, the juror who had given that long look down the aisle to Mr. McLeland. She's now making very quick looks out towards the audience, which this juror has not done before, has not been somebody who has been one of the ones kind of checking in on the audience and taking note of that. Video 12 was on May the 20th at 11:36 a.m. This is also a short video. Didn't notice any specific reactions to this video being played. I want to note at this point that before they started replaying the videos after the recess, Mr. McLeland is no longer sitting where he was. Ms. Diener has taken on this kind of sitting over here on this side of the screen. She's in a little bit of a different position than Mr. McLeland had been. He was basically like, if you looked straight down the first row of the jurors, he was pretty much sitting as if he would be the next in line. Ms. Diener is seated far in front of the jury box. So she's ahead. From my perspective, it looks like she's sitting even a little bit ahead of where the alternates were. And she's leaned forward to kind of be able to, I think, get the angle because of the way that the screen is pointed. Video number 13. This one is now apparently a throwing back. Like we're going back in time now, because I caught that this video was from April the 6th, 2023 at about noon. While this video is playing, this juror, the same juror who did the quick glance out towards the audience before, is now looking, taking a longer look out at the audience. I see another one of the jurors up at the top scanning the audience, and they're just like, while this video is playing, when I say scanning the audience, I mean they're just looking around at kind of everybody that is there and taking it in. They're not making expressions. They're not like trying to communicate anything or anything like that. They're just looking out. They're just looking out at all of us. I see a juror that I haven't seen previously expressing much, because I haven't been able to get a very good view of this juror. Some of the jurors are fairly blocked from my view, so I have to, it just depends on kind of where the jurors are as far as, if this one's leaning forward, it might block my view of that one. Some of them are shorter than others. And so like they can kind of get like tucked in and sort of lost behind the other ones. This particular juror is very hard for me to see. But I do notice this juror, I get a brief glimpse that this juror is tightening and doing that lip tuck kind of gesture. At this point, I also notice that Andy Baldwin, he is seated next to Mr. Allen, and he is holding him. He's got his arm around Mr. Allen's shoulders, not just across the back of the chair. He's got him around his shoulders. He's holding Mr. Allen, who is behind the screen. Mr. Allen is not watching the videos, so he's not watching this, but he's holding them while this video is being played. He only does that for a couple of minutes. I turn away. I'm looking at the jurors again. And when I look back, I see Mr. Baldwin's arm is still now, it's across the back of the chair, but he's no longer having that comforting contact with Mr. Allen. Video number 14 was on May the 30th at 7:09 a.m. At this point, I now again see two of the jurors out scanning the audience, looking towards the audience. I see the juror looking more on the side of the audience, that is the side of the audience where Kathy has been seated, and just taking a long look really through everybody. Is kind of over on that side. I see one of the jurors holding their face, stroking their chin. I see the juror who has been most reactive to these videos now shift his eyes away from the screen and look down in the direction, long look in the direction of either the prosecutor's table, or Mr. Allen. Can't tell which one, but really take a long glance in that direction before looking back at the screen. And then I see one of the other jurors, the one that has not been very reactive so far in this process, look down at this juror who has been the most reactive, like a look down, check in kind of at that particular juror, and look back at the screen. Video number 15 was from May the 20th. I didn't catch the time. And as this video plays, this one is also a little bit extended. I see the juror who has been the most reactive is now doing a head shake again. These are subtle. These are not like, these are not dramatic. These are subtle. They're very small. They're not, to my eye, intended to be communicative. These are just natural reactions to what is being shown. I see one of the jurors make an expression that's placing your tongue under your bottom lip. You kind of get a little bit of a jut like that. I don't know about you guys when I make that expression, but when I make that expression, it's associated with like anger, with like some outrage. I'm not happy if I make that expression. I don't feel joy making that expression. This juror is now holding her throat. The juror who has been the most reactive now does like a scratch to the head, kind of moves the hand down to the left side of the face, and then is back to that cupping of the ear pose with the middle and the index finger. Then looks out back towards the audience. Juror in the back row looks out towards the audience and then looks down the row at one of the other jurors. I see now a second juror glance down the row at the juror who has been most expressive, checking in on that juror. The juror who has been glancing over at the audience is still looking over at the audience while this is going on. The juror who was kind of the first one to turn and check in on the most expressive juror now does it a second time, looks down, quick glance at that juror, and then looks out at the audience. And this is like the first that this juror has really acknowledged the audience at all. This juror does not look at the audience at any point, like while coming into the court, while watching any of the process, while leaving the court. This juror doesn't acknowledge us at all. And at this point, that juror checked down at that reactive juror, and then does the audience scan before turning back to the television. At this point, I see Ms. Diener, who's been kind of leaned forward watching this. She scratches the back of her head and then she looks out towards the audience before looking back. The reactive juror is now slow blinking. Jurors, multiple jurors now looking back, looking out at the audience. Juror who has not previously hand covered the mouth is looking out at the audience and then comes back, covers the mouth in the watching pose. And it's like a, hand over the cheek, hand, kind of across the mouth. There's a moment during this video where it's like the most that I've seen all of the jurors at the same time have that instantaneous reaction to take the note. So like several, can't count while they're all doing this, but I would guess probably at least half of them, at least 6 of them, react to take the note at exactly the same time. One of the jurors, who's not been such an avid note taker, other people are taking the notes. This juror has not been much of a note taker. While they're taking the notes, this juror is doing lots of face and head and ear and neck touching. And one of the other jurors looks back out at the audience. The juror who's most reactive is now watching with an open mouth that has gotten wider. So not just the slight lip parting, more open, more ajar. Second juror is now watching with the mouth open. And then two of the jurors, the ones that had kind of communicated with each other before, they do it again. They have some type of communication between each other. And that was the videos. So they closed up with Max Baker just saying that he had created a similar thumb drive and cheat sheet, they called it in this time, for the in-cell video, which we didn't see for that one. The only difference with the in-cell video and the cheat sheet that's associated with it is that those videos are date and time stamped. So they don't need to, go to any trouble to specifically, be able to identify or call it out. Like the jury doesn't need that additional information on their cheat sheet. It's right there on the screen. So Mr. McLeland, still quite subdued, is then asking, should I cross now? Or are there going to be, more videos? Are there going to be more videos played? Like he's basically like, I'm not sure if I should go ahead and start my cross now, or if I should wait until all of the videos are played. So the judge asks, do we have more videos? And he's asking Mr. McLeland, do you want to reserve your cross? So they have their third sidebar at this point, the third and final sidebar. They go up to the bar, up to behind the screen. And while they're having this final sidebar, I am seeing signs of tension dissipation. I'm seeing a couple different pairs of jurors that are talking to each other and like smiling, laughing, chuckling, just strikes me as like tension relief. Somebody who has to deal with some grim stuff in the course of handling these types of cases. That's how it rang to me, because I have gone through that type of processing myself, where you see something that is not real pleasant. It's maybe hard to deal with, and there is just a little bit of a need to kind of lighten it when it's done, and kind of get yourself back into a more even type of emotional state. So at the conclusion of the sidebar, Mr. McLeland says that he will do his cross at the end of all of the videos. So there's no cross at this time, and we go ahead and break for the day. And it's 12 o'clock noon, so we got out a little bit earlier. That gave me time to have my first lunch out. Lunch out at like an actual restaurant. Went to I had arranged to have an interview with a reporter, and so we went to lunch at this Mexican restaurant there in town. I love Mexican food. I had a shrimp cocktail, which my husband will know. is like my gauge of a Mexican restaurant. Like you can gauge how good a Mexican restaurant is by their shrimp cocktail. Just little things like do they serve it hot? Do they give you saltine crackers with it? A shrimp cocktail is normally like served with a shrimp broth, maybe a little bit of a tomato flavor, but it's usually like a pico de gallo kind of salsa, some avocado, and then shrimp. So like, are these bay shrimp? Are these like nice big juicy prawns? Like what's the quality? Have they cleaned them? Like what's the quality? And then it's supposed to be served with ketchup on the side. So you add ketchup and you add saltine crackers to your shrimp cocktail. The shrimp and like the content itself was really good. Like my only beef with the shrimp cocktail was that they did like the ketchuping for you. You know, it comes out. It's not just the broth. It's like very red. And it was a little over ketchuped to my taste, but it was really nice to have a good, like have some good protein, have a good meal that I didn't have to cook for myself, in the extremely late hours of the night just to get some calories. Or, eat it out of a box, sitting on the floor in the courthouse. My PBJs and my tuna sandwiches and stuff like that. And then I came home, took a nap. Took me a long nap. Going to look forward to getting some sleep tonight. Really looking forward to it. There was something that I wanted to go ahead and share with you guys just for kind of analytical purposes, because I know folks have so many questions about the process. And one of the distinct things about this was the fact that the public wasn't allowed to watch these videos, that while the videos were being published to the jury. And so I did want to talk about that a little bit and also kind of share a little bit as far as like the public access rules and how it works as far as public records and what may potentially be at play and implicating our ability to see this. Because normally the presumption is an exhibit that's admitted in court. It is public record. But there are exceptions to this, and the most common one that you see like this, where it's the jury has to see it, it's admitted into evidence, but we are not going to display this to the public, is child pornography. You're not going to broadcast that out to the world. That is re-victimizing this child victim. Things like that, when there are crimes of this nature. Hate to say it, sometimes they're caught on video. Things like revenge porn types of crimes. Those are not going to be displayed to the audience. That would be re-victimizing this victim. So it's definitely not unheard of when there is certain type of content that is, particularly, graphic and disturbing and unsettling. Now, obviously, that's not the type of case that we're dealing with. But again, we have heard a little bit just through the notes from Dr. Walla about what was going on with Rick at this particular point in time. And so I wanted to go ahead and share with you, if I can go ahead and get the screen up, what some of the rules are if they want to not share this information publicly. So how well can we see this? It looks like that's pretty good. So we're looking at rule number 7. This is a very specific rule it's in the Indiana rules. I don't want that pop up. Indiana rules for public access. And so it's very specific to exhibits. Subsection A, it's presumptive that they are going to be public records. So I'll just read it out. A court record tendered or admitted into evidence during a hearing, trial, or an in-camera review that is to be excluded from public access shall be accompanied by a separate written notice identifying the specific Rule 5 grounds upon which the exclusion is based. And so this is like a fairly standard form that is, you basically file it if you're filing or putting anything into the court record that is confidential or otherwise not to be viewed by the public. And so these automatic exclusions from public access are set out in rule number 5. So I'll go ahead and take us up to rule number 5, so we can see what those things are and maybe get a sense of what is potentially at play here, because there are some grounds that I think we can probably quite reasonably infer are at play here. And so we're not talking about subsection A, because we're not talking about excluding an entire case from court from public access. We're talking about individual case records. So if there's going to be a case record, you're supposed to file it with this form, and Rule 7 tells us you would do this with an exhibit as well. So if it's confidential or excluded from public access pursuant to federal law, types of things I'm talking about, but there's also other materials that often through the federal system have to be maintained confidential. Records excluded from public access or declared confidential by Indiana statute or court rule. So these can be just a variety of different materials. If there's something that a statute says this is confidential. Case records excluded pursuant to like the rule that excludes the entire case, or by specific court order entered in accordance with Rule 6. So Rule 6 is like the catch-all. If these specific restrictions don't apply, there's still a process that can be gone through to keep certain information out of the public record. And Rule 6 is the process that was used to originally get that temporary sealing of the probable cause affidavit. The way that Rule 6 is set up is that you file the document and you file it with this like Rule 6 notification. And what that does is it automatically keeps that document confidential until there is time to have a hearing on it. And at that point in time, then the court will make a ruling on whether it is to be kept confidential or whether it will be made available for public inspection. So in this particular case, that's what happened. It was sealed initially for about a month because that's how long it took for them to have the hearing on whether it should remain that way. And then at the conclusion of the hearing, the judge ruled that the entire document, this was a ruling by Judge Gohl, that the entire document was not subject to exclusion under the Rule 6, but that certain information was specifically dealing with identifying information of witnesses, that there were grounds, justifiable grounds to keep that information confidential and redacted. So, but for those redactions, the rest of the probable cause affidavit then became available to the public at that time. 4, case records sealed in accordance with the Access to Public Records Act. It's just a separate statute that Indiana has that it deals with much broader government, access to records than specifically court records that this rule is designed to address. Records for which a statutory or common law privilege has been asserted and not waived or overruled. So things that are, for example, attorney-client privilege, doctor-patient privileged, things like that are that have common law confidentiality associated with them. Records in a pending matter that pertain to permissible ex parte proceedings, post-charging investigatory requests for process, or requests for in-camera review, and that have been ordered confidential by the trial judge. So an example of this that we're seeing is the defense has they got permission early on in the case for when they have to go to court and request funding, like expert funding, since it's the court that decides if they get money for that stuff or not. They're being allowed to file those requests under seal. It's probably not going to be permanently under seal. It's just temporary while the case is going on. And the reason for that is because this is getting very close to defense work product. If you know who I'm talking to, what I want to talk to them about, because I have to justify my defense request, I'm really cluing you in on, my processing of the case, my strategies, my thought process. And so that is a type of information that is pretty commonplace in courts where they have the oversight over the expert funding to be able to do that under seal, so that essentially the people who are indigent and have to rely on the court to get their due process really are on the same footing as the people that have the resources to go out and hire their own experts because they don't have to go to the court. They don't have to reveal anything at all. So it's kind of just an equalizing, making sure that everybody is on the same footing when it comes to that part of a defense investigation and case preparation. Okay, we said that. Number 8, medical records compiled or created by a medical service provider and examiner reports pursuant to Trial Rule 35. So medical records, potentially an issue here. We have heard that he was being medically evaluated during part of this process. Again, because we don't know specifically what's on these videos and if these videos are showing, if these videos are every time that he was taken out of his cell during this time period, we don't know that. And so it is just possible that some of these recordings may show him being removed from his cell for medical assessment to take place. Potential argument, I think, to be made there that's something equivalent to a medical record. Same thing with mental health records compiled or created by a mental health services provider for treatment purposes. If there is video recording, I don't know that there would be in this situation. There's certainly transport to and from the little cage that we've heard about, the therapy cage that they have there in the facility. But otherwise, he was not removed from his cell for the check-ins. We heard that they would just do the daily check-in by like opening the lunch slot and asking in, how you doing? So probably less likely that anything that was seen was going to fall into this mental health records, but that is certainly a possibility. Drug or substance abuse records, including test results when performed at the direction of a substance abuse treatment program provider, or a court or court program governed by 42 CFR Part 2. This is, I believe this is drug courts. So there's often, like you have to do your analysis, you have to just go through programming that can be different levels of intensity depending on like how severe your addiction is. Some people may require very intense individual type of intervention. Some people can just, go to more of a group setting, or just even more of like kind of an educational, like, you were dabbling and you're not like in bad shape yet, but you need to watch it. You probably don't need a whole lot of real intense intervention. So there can be a real variation in what those records would consist of. And some of those, again, are getting close to like treatment provider, mental health types of situations. Okay, here we go. This is what I suspect is at play for at least some of what is on these videos. 11, photographs, film, video recordings, or other similar mediums showing a live individual's uncovered genitals, pubic area, buttocks, or female post-pubescent nipple. We heard about this, that he was, naked in his cell a lot of the times. If he's going to be transported somewhere and the guards are showing up at his cell to take him out, he's probably naked. Good chance at least some of these he may be naked. So that could certainly be part of it. Number 12 as well, because we did hear about this type of activity in the notes. Photographs, film, video recordings, or other similar mediums showing a live individual engaging in or being subjected to sexual conduct. Yeah, we heard about this. We heard about this. This is what, to my mind, when Dr. Wanger yesterday was talking about these themes of delusion that you would look for, and you would look for the association between these themes and the confession type activity to get a sense of whether it is genuine or whether it is feigning. And hypersexuality was one of those. This is the type of behavior that I was thinking about because it has come up. The last one's not going to be applicable here, I wouldn't think anyway. Guardian ad litem or court-appointed special advocate reports, parenting coordinator reports, and custody evaluation reports. So things that have to do with children. When children and their welfare is at issue in court proceedings, that is not going to be... Kids need the privacy. They need to be kids, and they need to not, have their have their private stuff put out in public in a situation where that could be, just extremely damaging and detrimental and embarrassing to them, at a later age. So those are the main things that I think apply here. There's some additional options for when there is personal identifying information. I don't think that's, going to be an issue here. Child witnesses in cases involving sex offenses, that's not an issue here. Addresses and things like that who are witnesses, not at issue here. It's not going to be on these videos. Court administrative records, not on here. So then there's some temporary exclusions, and so these are, for example, this was like I indicated, the probable cause to justify issuance of an arrest warrant has been established. The case records shall be publicly accessible unless the judge determines that the facts presented in the request for exclusion from public access support a reasonable belief that public disclosure will increase the risk of flight by the defendant, create a risk of undue risk of harm to the community or a law enforcement officer, or jeopardize an ongoing criminal investigation. You don't want to, alert dangerous people that you're about to go arrest of the fact that you're going to go arrest them. So that is also pretty standard. This order expires immediately upon the arrest of the defendant. So that is also it's commonplace. You see rules like this in most jurisdictions because they need to be able to keep that, the fact that is about to happen, they need to keep that quiet. And then once that's no longer an issue because the defendant is in custody, they go ahead and release that information. And then they just kind of describe the, process of how you do it. That similarly with like arrest information, when they're talking about basically you're on probation and you're going to get arrested for a violation for that, it's the same type of rule that applies. You don't want to alert that person because that person can then potentially abscond or, otherwise, if it's a person who is a dangerous person, then they could, that could be dangerous. So this is the catch-all rule, the excluding the other court records from public access. The reason I want to bring this up is to just point out that, in my view, it's very unlikely that this video is going to fall under this catch-all. If the video is going to be withheld from public disclosure, it's probably going to be because of those things that we identified in the previous rule. I think it's most likely if there's medical treatment that's being shown, if there's nudity, and if there's sexual conduct that is being engaged in. Those things are entitled to be kept confidential if the defense so requests, by basically filing this form with the exhibit at the time of introducing the exhibit, like we heard from the process. So this is for extraordinary circumstances. The standard to be able to exclude a document that doesn't fit within any of those categories and would otherwise be publicly accessible can be excluded from court access. And any person affected by the release of the court record can make that request. The request has to demonstrate that the public interest will be substantially served by prohibiting access. So it's the public's interest that we're most concerned about. Access or dissemination of the court record will create a significant risk of substantial harm to the requester or other persons or the general public. So it would create a potential danger. A substantial prejudicial effect to ongoing proceedings cannot be avoided without prohibiting public access. And when this request is made, the request and the court record will be rendered confidential for a reasonable period of time until the court rules on the request. So that's what we saw with the probable cause affidavit. And as far as kind of how that all played out, I, take issue with the entire sealing of it from the very inception. I certainly am well aware of what was going on. We heard Cheyenne Mill talk about her experience of what was going on with kind of some of the social media elements of the case. Just a investigative, suspicious, accusatory type of climate that was potentially, detrimental to witnesses to the case. And so I can certainly understand, and I, really don't take issue with it even to this day, is the probable cause affidavit, not including the identifying information of the witnesses up front. I don't really have problems with redacting that. Because there is that risk of blowback and tampering and interference and stuff like that. And it's not something, from my perspective, that the public necessarily needs to know right up front. We need to know that there are witnesses. The defense certainly needs to know who they are because they need to be able to investigate that, but they will have access to that information. So I don't necessarily take huge issue with this because I think it is important to the integrity of the process that witnesses feel safe to be able to come forward and provide the information that they know. If they know that their identities are going to be public, particularly in a case that's been associated with a lot of attention to the witnesses, then that's going to be very discouraging to people to come forward and be witnesses. And that's really not in anybody's interest, not in the public's interest, to have people afraid, to say what they know. So that was basically how that process worked. But because of that standard, and I just wanted to point that out, the way that it's really focusing on the public interest and the significant risk of harm to the requester, other persons, or the general public, or a substantial prejudicial effect to ongoing proceedings, it would have to really be creating a significant risk of substantial harm to other persons, or to, Mr. Allen, if he's the one making the request. Could we argue this creates a significant risk of substantial harm to men? I mean, maybe. I don't know what's on the videos. Doesn't really seem out of line to me that this would be very psychologically damaging, to have video of you in a breakdown, in your worst place, not in your right mind, out there for everybody in the world to see. But I think the challenge here is the public interest will be substantially served by prohibiting access. I'm not sure what that argument is. The public interest in a court case is generally served by transparency. Being able to evaluate for ourselves the treatment that he received. That was documented. That's going to be something the jury considers as they're making their decision. I mean, one of the things that we've talked about here is, if Mr. Allen is acquitted, there's going to be some blowback for that. This case has become so extremely polarized, people with very strong feelings on both sides. And that's without, sitting through the trial process. A lot of people with opinions, strong opinions that haven't been here in court watching the evidence. I mean, understandably, because you can't. And it hasn't been a process where we're all able to watch it together on a live stream or listen to it on an audio and be able to debate it the way that we typically debate things that are out there in the public forum. So a lot of these opinions, it's like they're already fixed. There's already kind of an anticipation, an expectation of what the evidence is and what it's going to show. But if we haven't been in the trial and we haven't seen it, then we don't know. We don't know how to evaluate opinions about the case, opinions about guilt or innocence. And so that process, if he's acquitted, there's going to be blowback. And I've already suggested that, unfortunately, given how the testimony from the primary investigators in this case has come out, that the people that are leading the investigation into the murders of Abby and Libby, the way that their testimony has come out, they're closed. they have decided that Mr. Allen is the perpetrator, that there's no other possible explanation for how this crime occurred. And so I think it's just extremely unlikely that if he were acquitted, that they would pick back up and continue to look for the killer. That the likely response to that is, well, the jury got it wrong. And so if we can't see for ourselves what evidence the jury relied on, we're not in any position to be able to evaluate if these guys aren't continuing the investigation. Is that a problem? Is that something that we should be taking issue with? So I do. I find it hard to justify this particular rationale for closing off really anything in the evidence in the court case. It is presumptively open. If it doesn't fall within one of those specific exceptions, which I do think some of this video might, then personally, I think it's probably most of the time going to be in the public interest for that to be available so that we can monitor it. These are our courts. I say many times, this justice is done in our name. It's the state of Indiana that is conducting this prosecution, and this is occurring in the United States of America, subject to the constitutional restraints imposed by the United States Constitution that we all have an interest in seeing upheld. So the criminal justice process, it's done in our names. We have every interest in monitoring it and making sure that it is being conducted in a way that we support. Because if we don't support it, we might choose to exercise our power to vote out the people that are making the decisions about how it's run and bring in some others who will operate in a way that is more consistent with our community sense of justice. So that's really all I have for you guys on this today. Like I said, it was a short day and I got some extra sleep. It's so early by my normal standard now. So we're going to have some time to go through your super chats. And I'm still going to get a nice full night's sleep tonight. I can't tell you how much I'm looking forward to that. So we'll start here with Mudbug. Thank you, Ms. Andrea, for being our eyes, ears, and voice, along with so many other people with good minds and good hearts. Again, thank you and all others. There have been just some wonderful, good-hearted, well-intentioned, caring people for whom this process matters a lot. And it's just been such an honor and a privilege to get to meet so many of these folks through the course of this trial process. This whole experience has unfolded so much differently than I had in mind. You know, like you envision, you know, how things might be when you're thinking about doing something like this. And this is it's just been so different. I just never expected that it was going to be like this. It was going to be like such a trial by fire that we all shared to be able to get into the courtroom, that by and large, I think helped bond a lot of people that have participated and shown up. Certainly did not anticipate that, you know, I was going to be presented with the opportunity and the calling to fight for public access and transparency in the case. So it's really been an honor, and I'm very glad that I came. Debbie Enlow, thank you, Andrea, for all your hard work. You are very welcome. Bird with a $10 super sticker. Thank you so much for that. Really appreciate it. Monkey Bones. Hello, Andrea. My wife and I absolutely love your coverage of this case. Has anyone covered the fact that the sticks on the bodies were cut with a tool saw? I read this somewhere, and there's no way Richard Allen had time to do that. So far, that has not been elicited. That is a piece of information that I do wonder if it might be helpful to bring that out. My view on it is that the state would probably try to diffuse it by, you know, some type of argument that I'm not sure that you can date and time when a branch is sawn. And so it's possible that this was just something somebody else in this area had cut this branch, and it just, is the one on the ground that happens to be used to to be placed on the bodies. I mean, wood quality does change from being, a fresh green wood cut to a, more aged. There's moisture, moisture in fresh wood. And so that evaporates and the wood dries. The cambium under the wood is often really bright green when you first cut it. And as time goes by, it will become darker. So, and I say this from the perspective and experience of somebody with a fruit orchard. I prune a lot. Somebody with bonsai tree collections that I prune a lot. So I do a lot of cutting of wood, seen a lot of cut branches, and have to haul them over to where they get stored until we get the wood chipper up and process them. And so sometimes that's right away. Sometimes it might be a few months. Just depends on the circumstances. Take it however you want. But it's just, it might be one of those pieces of information that maybe just there's some ambiguity to it. I don't know. It could be an oversight. It could be something that just got forgotten along the way. Not really sure who they would get that information from. I guess probably the lab. I guess that should have come from the lab. As I recall, it was the defense's. It was one of the defense's odonist like when they were having the third party culprit hearings. I'm pretty sure that the marks, the saw marks on the branch, was from one of the defense witnesses. So it could be that they had anticipated that they'd be able to elicit this through their odonist witness. I just don't know. But the only person that has really described inspecting the branches was the DNA analyst, the one who set up the mobile lab after they were brought in and did that testing of it. So it's possible that witness, didn't notice or didn't document, and so wasn't going to be able to be elicited from that witness. The investigators on the scene didn't really seem to be that interested in the sticks themselves. They just piled them up and left them there out in the open and then abandoned the scene. The DNR officer, when he came across them and suggested these should maybe be taken into evidence, the only thing that he noticed that called his attention to it was the fact that they had blood on it. And we didn't hear from anybody who actually took the sticks into evidence, I don't think. Did we? I can't remember now. But no indication of any particular observation about the quality of the sticks at that point in time. So it could just be a situation, where they didn't notice, and so it's not something that you can elicit from the state's witnesses. If it's going to come out, it'll have to come out from somebody on the defense side because they're the ones who caught that detail. Conrad Lawrence. How hard would the defense team be slapped if, in closing arguments, they asked the jury to imagine a 13-month sequestration? So you generally cannot ask the jury to put themselves in the shoes of any of the trial participants. It goes just as much for put yourself in the shoes of the victims as much as put yourselves in the shoes of the defendant. Because that's arguing for like emotional decision making. And that's just, it's not what the jury's role is. But they can do it. They can do it around the edges. They can do it around the edges. They can point out that, this required an extended separation. He's jerked away suddenly from his family without notice, against his will. It's not something he wanted to do. He didn't volunteer for it. It was something that outside forces brought and required him to be separated from his family that he missed terribly. And he didn't get to sleep in his own bed. He didn't get to dress in his clothes. He had to, lose his ordinary day-to-day routine. They can just draw the picture in a way that the jurors listening to that can hopefully just make the connection for themselves, that they'll be able to relate to that and, make that connection with their own experience that they're currently having during the process of serving on this jury. Because yeah, there are a lot of commonalities. This jury has a responsibility. That's a little bit different than Mr. Allen's situation. He just didn't have any choice. These jurors have a duty and a calling, that is bigger than their personal comfort, and that's part of why the sequestration is ordered, is because of the significance of the task that they're being asked to do. But otherwise, yeah, they could think about, wow, I've had to go through it like this, and it's been hard, and I miss my people, my friends that I'm used to talking to. I miss I used to hate going to work in the morning. It was just a drag, but now, like, I miss being able to see my coworkers and that regular routine and that schedule that you have. And, the way that the legal assistant would make my morning coffee, just the way I like it. I never get the coffee the way I like it myself. Just little things like that, that they have the potential to relate to, and then think about how much different would it be to be having those types of experiences while you're locked away in a tiny cell with the lights on 24/7, with no real human contact other than people, dangerous, scary inmates screaming abuse at you through the walls. I mean, they heard that phone call and the hellscape of yelling that could be heard in the background. So I think they can do it in a way that makes the point. They don't have to do that explicitly. And so it wouldn't really be necessary to draw that fire for themselves. Carrie Ann, do you think the jury could interpret the videos as if someone this psychotic is capable of killing 2 girls rather than it being a result of his confinement? Do the pre-arrest videos make a strong enough distinction? There is a massive, that's the question as far as what we see on the videos, because we don't know. But I can tell you that the interrogation videos that we saw of Richard Allen are exceedingly normal. He's a very normal guy. He's not presenting like some psychopath. He presents like a very, very normal dude, doing things that I think most people could relate to if they put themselves in that position and think like, gosh, if somebody is really accusing me of doing something that I didn't do, and they're not hearing my explanation, and how frustrating that is, and you're trying to get through to them, and it's like talking to a wall, and what that experience is like. What would I be like in that situation? Would I look like Mr. Allen did? I think that's a pretty reasonable, a reasonable place for people to be. It's certainly where I was watching this. Like, I don't see anything weird or out of line or outrageous about this at all. He seems very normal. And then he leaves the room and tells Mullen, "You're an asshole." And like everybody in the courtroom kind of laughs because they're like, yeah, yeah, he was. That was me. I'd be thinking, God, that guy's an asshole. Unbelievable. And so, not knowing what they've seen on these videos, I don't know. But if it's, if it's depicting the kinds of things that we have already heard described, then yeah, I'm pretty sure that the distinction between those things is going to be very sharp. This is very much an issue that I worried about as well. The way you point this out, it's almost like it can't win. I can't win. He's just in a bind, damned if you do, damned if you don't. You have to present this to be able to explain why he was saying the things that he said, because he lost his mind. But yeah, it feeds into the potential pre-existing narrative and just assumption that somebody who would do these types of things to these girls, that person has to be like psychopathic. That person has to be a monster. And so now if we see Mr. Allen and he looks like a monster, are we able to make that distinction? And so that's why I think it was so important and such a big victory for the defense that the jury got to see the interrogation videos and not just hear them being described, by the state's witnesses. Nick McLeland is as dirty as his hair, aka Uncle Lewis. Great username there. Andrea, thank you for being our eyes and ears. You have brought this trial to life for us. You are the transparency they didn't want us to see. Well, I'm just glad I could mess up their plans in that respect. It's wrong. It's wrong. This needed to be seen. So out on the courthouse steps this morning, one of the sheriff's deputies, who is not, I don't know what his role is, but he's not like one of the young kind of rookie-ish younger types, that has typically been, out there kind of on the morning watch, so to speak. They've been very friendly, very, nice to talk to. Really enjoyed talking to them. This guy is more of a grizzled veteran. Often a lot of times in the trenches. Same thing happens with defense attorneys as happens with police. You can get real jaded. Apropos of nothing. But anyway, this particular veteran deputy comes out, and it's cold. It's very cold this morning. There's frost on my car. I was a little bit late getting there because when you rent a car, they don't give you an ice scraper. So I have no ice scraper. I'm sitting there having to wait for the defrost to get the ice off my windshield before I can go. Thermometer said about 32 degrees when I was heading there. And the trend has always been that it continues to get colder and colder and colder until just right before the sun comes up. So like 7 to 7:30 is sometimes, that's like the coldest period that we're out there. So it is really cold. People are out there bundled up, very heavily bundled up. Big, thick sleeping bags and heavy blankets and things like that. And so this deputy comes out, and he's kind of taking this all in, and he's asking some of the line sitters, God, did you guys really camp out here? Did you really sleep out here? And they said, yeah. And he's like, let me just ask you one thing. Why? And it was this kind of it wasn't the sort of why that's like, I'm interested in the answer. It was the kind of why that's like, I'm expressing my I don't want to like use a strong word like contempt or disdain, because I don't think it necessarily rose to that level, but it was just sort of like a little bit like, you guys are crazy. Like, why are you guys crazy sleeping out here in the cold like this? And so I answered, because this really matters and people need to see what's going on in the courtroom. And he said, oh yeah, well, I kind of thought you were going to say that. Well, yeah, I am going to say that. I mean, that should mean something, I would think. Does that not compute that this is so important to so many people that they're actually sleeping out here in the cold? Like, justice matters to people. And it's important. It's important for law enforcement. Don't get so jaded. Don't get so jaded that you forget that justice really matters to people. Maybe just, if you find yourself in that perspective, maybe you want to stop and check where you're at. Make sure you're okay. Policing is not an easy job. It's not an easy job. There's a lot of traumatic exposure. There's a lot of risk. And yeah, it's real easy to get kind of numb to that and to get real jaded. And that's not a healthy place to be. KP, question, going back to yesterday's third-party ruling, does the defense have any recourse when the case law is so clearly on their side, i.e. nexus? The case law, as far as what a nexus is pretty clear. Their recourse on this is really always going to be appeal. They've made their legal argument. They've made it clear. We know what a nexus is. The disconnect here is in how that is being applied to the facts of this case. To me, it's incomprehensible that what they've presented doesn't establish a nexus as to at least some of these individuals. And then just because of the linkages between them, there's different pieces of the puzzle that fit together when you look at it as a comprehensive whole. So you have a direct link from somebody that's telling people he did it, telling people about it. There's a witness, one of the witnesses, who talks about loaning her car to one of the people in this linkage over Valentine's Day weekend, and when it comes back, there's blood on the door. You have one of these individuals with the linkages who has a direct relationship with the victims. The son is the boyfriend of Abby, and has distanced himself from that. You know, originally saying, "Oh, never met her," then met her one time, then met her a couple times. So yeah, when you put all these things together, it's kind of hard for me to see the argument that there's no nexus here. Because again, the legal standard is not like you have to actually prove beyond a reasonable doubt that somebody else committed the crime. You just have to prove that there is a reasonable inference that they did, and that it's beyond just supposition. It's beyond just opportunity. Lots of people have the opportunity to commit a crime. You know, crime occurs out in the woods, middle of the night. A lot of people in the area, like pretty much anyone who is in the vicinity, has the opportunity to commit the crime. But that doesn't mean there's a particular reason to think that any of them did. And that's really all that the nexus is getting at. You can't just point at like, oh, my neighbor had a key to my house, and so therefore he's the one that came into my house and murdered my wife. You can't do that. You would need something more targeted to suggest that he actually did. So maybe he's behaving suspiciously, surreptitiously, like trying to look in your windows. Maybe his fingerprints, you know, show up on the outside of the door, or like on the casing of the windows where there's a break-in. You know, things like that tend to put you more to, okay, well, it's a possibility that this person did this. Confessing to it to somebody, yeah, that's a pretty good link. Here we are in this trial with lots of people still insisting Richard Allen is absolutely unequivocally guilty because he confessed. So what about the other guy that did? The other guy that confessed, who wasn't in solitary confinement being mistreated at that time. So there is not going to be recourse with Judge Gohl on this. They have made their legal argument. They've made their case. They've made their record. If there's going to be any recourse on this, it's going to be on appeal. If he gets convicted, it's going to be one of the issues that they raise. And from my perspective, it's going to be a very strong one because I really fail to see how these facts don't meet that particular standard. That Mickey, could it be that some of the jurors presented this way because they knew the entire court was looking at them and they were uncomfortable, or did it seem clear that they were disturbed by the videos? I mean, you can never say with any certainty, but just because of the way that the reactions evolved and the fact that they changed, and that especially some of these jurors were showing these types of reactions that they have not shown at any other point in the trial. They've been on display, you know, throughout the entire trial. So yeah, I can see how in this circumstance they might be aware that there is more like unique focus on them. But they know people have been watching them throughout. I don't know that there was anything like really so drastically different. Just because of the fact that they were all that we had to watch today. But it could. I mean, I certainly can't rule that out, that might escalate their kind of natural anxiety when they're watching these videos. But yeah, I think the way that they evolved, and the fact that the jurors began to behave atypically from the way that they have throughout the rest of the course, and that it took place over the process of watching the videos. Initially, we're the same that we've always been. We're not showing initial signs of comfort, which is kind of what I would expect. If we're uncomfortable because we know we're being watched, you're going to have that the most, like when you're first getting used to it. And then, it might settle down because you just, people can get used to almost anything. People are remarkably adaptable. So, of course I can't say definitively what any of this means, and I'm certainly I'm not trying to read minds. I'm trying to stick with behavior and what that behavior seems to indicate, when you can, go ahead and try to replicate it for yourself. And just see how that makes you feel when you're making some of those expressions. Mendy, we love line sitter volunteers. We do. Yes, we do. Please consider signing up to hold a spot in line for Andrea at the courthouse. The link is at the bottom of the video description. Mindy is my angel from heaven. I'm so grateful for her. She has been such a blessing. And is such an important part of why I have been able to do all of this, because frankly, it was not going to be sustainable to be out sleeping out at the courthouse every night, to be giving you all of this detail that I've been able to take down in the live streams, and be able to write and file a writ petition to the United States, to the Indiana Supreme Court, to try to get us access to the audio recordings of the trial and to allow us in the courtroom to be able to see the exhibits the same as the press is being able to view those exhibits. I wasn't going to be able to do all that and maintain it. So Mindy is a huge reason, because she took this on herself. She just showed up one night, decided, why not me? There's a problem that needs to be solved, an action that needs to be taken. Why not me? And so she just showed up, took it on herself to save the seat for me. Tell me, Andrea, go sleep in your car. And I did. And then she has been in charge of keeping things organized and running smoothly and coordinating, just to help. It's been such a blessing with this whole problem is all of the people, the helpers come out, it really is true. So thank you so much, Mindy, for everything that you've done. I just have an enormous debt of gratitude for you and everything that you've done, the time that you've put in. I can't say in words how much it means to me. I hope someday I have the opportunity to be able to repay you for that. Shy Gal 8, thank you so much, Andrea. You're truly amazing. How did RA do today? Worries me to have to watch that. Yeah, so he was behind the TV. He didn't have to watch it. And I think that was probably good, probably a bit of a blessing. He did have that moment, the one that I caught where, Mr. Baldwin was holding him around his shoulders, holding him, giving him that human contact that he hasn't had for almost 2 years. A simple hug. Allegedly obsessed with law and crime, newer criminal defense attorney late in life, I have learned so much from you. You recharged me to defend my clients. Thank you for your coverage. Well, thank you so much for that. It is a hard job. This can really, really wear you down, this line of work. And so, I understand burnout is rampant in public defense. It is a thankless job. It's an undercompensated job. It's an underappreciated job. It's a job that is disrespected a lot of the times publicly because people misunderstand it and think it's something other than what it is. It's a very difficult, emotionally challenging job because you see so much ugliness and so much injustice, so much unfairness. And that can really, really wear on people in the profession. And they tend to take a lot of blame for the problems. Look at this particular case, where when Judge Gohl reviewed the safekeeping order, Mr. Rosie and Mr. Baldwin filed a motion to reconsider the safekeeping order based on what they were learning about these conditions of confinement out in Westville. And they had a whole hearing on it, and Judge Gohl signed an order basically saying they were being dishonest about it. That much of what they represented about these conditions, it turned out not to be true. And in fact, Richard Allen was being treated better than other inmates at Westville. You get maligned. Things go wrong. It's your fault. People look to you as the one to blame. It's not an easy job at all. So that means a lot to me, this comment, because I know how important it is for folks who have made this is their calling, defending the accused, standing up for the rights of people that nobody else wants to stand next to. Nobody else wants to stand next to these people, but I will. I'll stand up for them. I'll stand up for their right to be treated fairly. Pretty much every defense lawyer ever has always been inspired by Atticus Finch, and we all, I mean, okay, I won't say we all. I'm being, that's because there are bad eggs in defense, of course, as well, just like there are in any profession. But the overwhelming, people that are called to this line of work, you're not getting rich from it. You're not getting famous from it. You're not getting, a lot of acclaim from it. You're doing it because it matters. And so it's very easy for the system to beat you down and to feel like just everything, all that you're putting into it, all the sacrifices that you're making, and it's just, what's it worth? It's really easy to get into that mindset. So it's really important for particularly people in criminal defense, and particularly those of us who, made it our career to represent the people who don't have the resources to go out and hire an attorney. It's important for us to have each other to commiserate with, and to understand each other, and to see each other, and to appreciate each other's struggles, and to help uplift each other. Continue to be motivated, and understand, like, yeah, some of the stuff you see, it's going to make you cry, like ugly cry, and that's okay. It's right. It should make you ugly cry, some of the stuff you see. But the fight never ends. The fight never ends. So thank you for being part of that fight. Lauren Boborin, allegedly obsessed with law and crime. Same. Finished law school in May, second career. I watch Andrea to learn because she makes me want to do it the right way. You guys are awesome. Law as a second career, it's great. Like, I totally recommend it. It's never too late. One of the nice things about the law degree is that it just opens so many different doors. It doesn't mean you have to go down any particular path. It doesn't even mean you have to be a practicing attorney. A legal degree can be so helpful in so many other types of jobs. It can help you advance. You have better understanding of things that can come into play in careers like real estate, human resources, stuff like that, isn't necessarily the attorney handling, litigation and compliance and things like that. But it just gives you much better information to be able to do your job better and be more qualified to understand things at kind of a higher level. So it's really just a big opportunity. If that is something that's open, available to you. And by the way, you can do it without having to assume a large debt burden. This is one of the traps. This is like the biggest trap that there is in law school is the cost. Because you come out with a massive amount of student debt, it really limits your options. Limits your options of what you get to do. And you can get stuck, and you can, find yourself in a position that you hate what you're doing, And the law is a cruel profession in many ways. It takes up so much of your time, so much of your attention. You don't get the luxury of vacations and holding your children as much as you would like, and going to their games and all of that type of thing. It can just have a massive impact on your own personal life outside of your work. And so the debt is the trap that gets you stuck there because it's so risky to leave. So that's always the big piece of advice that I have, just from a practical matter. Anybody that is considering law school, do what you can to minimize that debt coming out. You will be much, much happier on the other side because you will be more free with what you can do with that degree. Mavis Kane, what was the reaction of the family of the girls while showing these videos? I wasn't watching the family because they weren't going to be able to see the videos. So I didn't pay attention to that direction. Lizard of Oz, does the court offer therapy for jurors that have to go through a difficult trial? So this is a sort of new thing that has started to emerge because, yeah, there is a recognition that some of what these jurors have to watch and have to see and process is extreme, and it can be extremely upsetting and traumatic. And people can be severely affected by having to go through these types of processes. So it is sometimes available. This is kind of like I said, a new thing that is starting to emerge in some jurisdictions. I don't know if this type of thing would be available in Indiana. Indiana has done quite a bit of jury processing reform over the last couple decades, trying to make it more of a user-friendly type of experience. Talked about that yesterday. I think I might have. I know I talked to people about it yesterday. I guess I just don't remember if I talked about it on stream, but we've been talking about this rule that the jurors can discuss the evidence before they go into deliberations. The limitation is just they all have to be there and they have to keep an open mind. But that is the type of, like, when I hear that, I'm like, wow, I've never heard of that. It's so weird. Like, that's very different, not the conventional way of handling a trial. But that was a change that Indiana made as part of this just reconsidering of how the jury process should work and what it should look like and so forth. So it seems possible that because they have had that focus, that they may have something like this in effect, but I'm not going to lie, it's very, very rare that you're going to find something like this. So I kind of do hope for a trial like this that they have resources like that available, because this is hard. This is a hard case. And these people are coming in not from the type of, background where you might expect, oh, you're already kind of desensitized to this type of thing because, lawyer, you've handled lots of murder cases. You've seen, you've seen dead people. You've seen disturbing stuff. You've seen, defendants doing extreme things. But most people haven't. So it's a really, really good point that you're making. And I definitely hope that there is something like that available. Randy Gutierrez, Andrea, your coverage of this case is great. Thank you for answering all of my wife's questions in court and mine. Great chat about the Grateful Dead today as well today. See you on Friday, Randy and Angie. Yeah, it's been great chatting with you. We had a wonderful chat about the Grateful Dead, Big Deadhead. That's like pretty much all I've been listening to recently. They have the Grateful Dead archive on the Internet Archive. Whole big library of just the different recordings and stuff. And so one of the options you have is This Day in History. And that's just kind of been my default for a long time. If you, like, when I'm on the road or whatever, need something to listen to, just go ahead and get This Day in History and, pick a Dead show, listen to the Dead show from that day. So yeah, I'd love to hear more about some of the shows that you've been to and stuff like that, because that was an experience I missed out on. Jerry died while I was still in high school, so I never got to see the whole band live. But I got to see Phil and Friends, and I got to see Dead and Company in the Gorge last summer. So Lost Aurora X, as a psych registered nurse, I've seen the behaviors described many times, but never from someone whose psychosis was the result of such egregious maltreatment. Yeah, psych nurses, you guys have seen a lot. You guys have seen a lot. And yeah, there's some very disturbing behaviors sometimes in the psych hospital. I mean, I understand that. I appreciate that. To see a man who was just so seemingly normally functioning the day he was taken into custody, very normal. See him degrade to such an extent. It is. It's really pretty shocking. Brianne Lusick, thank you for your detailed coverage. I read reports that a psychologist juror was very attentive to the videos. Did you also observe how she reacted? So I have tried to go back. I haven't had much time to go back through my notes from jury selection, but I have had a bit of a hard time being able to relate my notes back to the people that ended up being seated on the jury. And the reason why is because there were all types of different numbering systems that were used to identify the jurors. So they first were assigned a juror number on the panel, but then they were like randomly sorted when it came to the order of how they were seated. So those numbers didn't go in order. And then they would be seated in the jury box, and they would then also have the box, the number of the chair for where they were seated. And so my notes just became a bit of a mess because there was a lot of back and forth with how these numbers were referred to. So I found it very difficult to kind of consistently, trace back through who these individuals were. It's going to take me a little bit more of a deeper dive, just more time that I've had to spend on it, to go back through those and kind of work backwards. Okay, here's who ended up on the jury. What can I trace back through my notes about what we learned about this individual? So I don't know which one the psychologist was, but I'm here to tell you that every single one of the jurors was extremely attentive to the videos. Every single one of them was very attentive to the videos. And it was only like as the reactions started to get strong that you began to see people looking out, towards the audience. And again, I don't want to mind read. I don't know what people are thinking. It looks like we just kind of need a break. It looks like just maybe kind of appreciating, we're not seeing what they're seeing. It looks like it's maybe questioning, like starting to think about, all of these people are here and they're here for a reason. They've cared about this for a reason. The courtroom has been completely full every day. So I don't want to read their minds. I don't want to say like it's any of these things. I'm just kind of trying to put myself in the position of if that had been me, what I might be thinking and what I might be doing that. It doesn't look like it's bored because as soon as they're, coming back, they're attentive and they're continuing to have the reactions that I've described. So everyone is very, very attentive to those videos that they saw. Nick TTT, is the FBI able to testify at all, just not impeach? Surely she can't stop the defense from calling him and having him go through his report. He was an investigator on the case. Thank you, Andrea. So this particular FBI agent, the problem that they have, here's the problem that they have. The contents of the FBI agent's report, his report in and of itself is hearsay. It's a written document, written words created outside of court, offered for the truth of what they say. So the report itself is hearsay. And then what the report is reporting is what they were told by Brad Weber. So they were told it by Brad Weber out of court for the purpose of, establishing the truth of the matter asserted. At least that's, one possibility. I think there's an argument that it's not hearsay, that we're not trying to say definitively Brad Weber was there at the bridge at 3:30. Like, we don't really care when he was there. Our point is that you can't rely on what he says about when he was there, because he said multiple things about why he was there that may correspond with his personal interests in what's happening with that particular information. So, that aspect of it, I think is arguably not hearsay, but, I don't think they're going to sell that on the judge. They've clearly been kind of boxed in with having to handle this as a prior inconsistent statement. So they've got a lot of difficulties now with this, because now it isn't just this legal foundational issue that they need to overcome to be able to get it in. It's also their witness. They may not be able to get him back before the trial is done, because she's not going to let him testify remotely, despite having reasons that in pretty much, most situations, these are considered good reasons. You're not available. You have this pre-existing conflict with the work that you can't get out of. I mean, election duty by the FBI is pretty important. The defense didn't decide when this trial was going to be. They didn't decide when it was going to be time to put on their case, So those types of things just happen. And then it apparently is compounded by a medical situation that makes travel very difficult for this man. So I don't know if they're going to, it's not just a legal problem that they have being able to get the content in. It seems like there is a real logistical problem in being able to get his testimony presented, because if he can't be here and if Judge Gold won't let him testify remotely, then they can't get him. And so now we're just in a situation where, it's not that the defense has nothing to work with here. They've already seen how Brad Weber reacted to that information. And they saw the other officer on the stand too, being asked, he's being asked to review this report and being asked if it, refreshes his recollection about what Brad Weber told him about when he got home from work. And no, he doesn't. Like, the jury can read between the lines there. And there's just been, there's been so much self-evident dishonesty by the law enforcement in this case, mostly specific individuals, but it has the effect of tainting the whole thing, because you kind of start to have to question everybody. Can we rely on anybody that's operating within the system? They also have that whole issue with Dr. Walla, Dr. Walla, and her admitting that she was sharing case information with him. We already knew he had the discovery. So they might have other avenues to, not directly go after Brad Weber with this, but just to point out this wasn't unique information that was available to him. If this was something that he, could have come up with based on materials that were in the case file in the discovery, or information that was available online in part of these discussion boards that Dr. Walla was a part of, like every single one, then they can attack it that way as well, and just point out, the prosecutor told you this was unique information, but it wasn't. And given what we know, what they themselves have admitted about how they handled this information, we can't say that information wasn't fed to him. Reasonable doubt. So, yeah, it would be really unfortunate if the FBI officer isn't able to call, and I would hope and expect that they will make an excellent record of what that testimony would be. And they filed a motion with the grounds for asking for him to testify remotely. Maybe they would supplement that with kind of some more details about exactly like why his medical condition prevents him from traveling and stuff like that. So that it's just one more issue. If he does get convicted and this case goes up on appeal, that they can raise is like, look, this is an important part of the defense to be able to directly undermine this testimony that the white van is there at the bridge at exactly the time that it's conveniently supposed to be to correspond with the story that Mr. Allen has allegedly given. Jojo, my husband asked me, "What are you crying about?" I'm like, "I don't think I can explain because I'm not sure, but I know it's really bad." This is a hard case. This is a hard case. This is I've described this case as just there's evil everywhere. Everywhere you look in this case, there's evil. The murders themselves, these were evil. The treatment of Richard Allen, this is evil. And from my personal perspective, the way that he's being prevented from being able to defend himself, from getting a fair trial, at risk of having to spend the rest of his life in prison, that's evil too. So there's just not a lot of light to find here. We have so much, that's why we're putting so much hope and faith and prayer into this jury, because they're really the hope that we have. They're the hope for justice. And that's, with all of its flaws and problems, when it works, that is the beacon of hope that the American jury system gives us. That ultimately it's ordinary people like you and me who are charged with the duty and the responsibility of making sure that justice is done. And so they've seen the same stuff that I've been telling you about. They've seen it all. And my process in all of this has been not to hide my opinions and my conclusions and stuff that I'm reaching from it, but to show you the process from the information that we're seeing, to show you my thought process and how that works for me. The jury is going to be going through a similar process. They're seeing the same things. They're going to be thinking about it and analyzing it. Of course, we don't know, how they're going to reach, how they're going to ultimately process it. But if we're all reasonable people, that's the hope we have in the jury system. We just hope that people are attentive, that they care. They care about getting it right, and that they're careful about the decision that they make. So yeah, it's okay to cry. It's okay to cry. This case has been really ugly. Jenny, thank you, Andrea. Love watching your detailed recaps. You and Lawyer Lee are my favorites. Thank you for everything that you do. Get some sleep. I'm going to. Absolutely. Looking forward to it. Thank you so much for that. Brianna Lusick, thank you for your detailed cover. Oh, I think this is a repost. So yeah, same comment about a psychologist juror was very attentive. Yeah, they were all very attentive. Each one of them was. Tony Elia, hello, Andrea. Not only is Judge Gold using the prosecution to carry out her agenda, she is also using this jury. Her game has a very high cost. Nobody wins. Yeah. The distortion of this process has really just been something to see. It really has. Now, the rules don't matter. And it's a different playing field when it's the defense's turn than it is when it's the state's. It just really is something else to see how the thumb is on the scale. And it's easy for me to see as the lawyer because I know the rules. I know the background information. I can make sense of that and interpret like this is wrong. The jury doesn't have that. And so it's just hard to know if they're getting that perspective on what's happening and why they're being allowed to see some things and not other things, and why so many of the state's objections to what the defense is doing are being sustained, and the defense hardly objects at all. But when they do, don't necessarily have a great track record. It's it's hard to know how all of this is landing with them. Cookie Harris, you are a true gem. As John Lewis once said, a democracy cannot thrive where power remains unchecked and justice is reserved for a select few. Yeah, that's tyranny. That's tyranny. Your work and passion are the beautiful breaths of democracy which breathe motivation into us all. This is political speech, man. This is the public forum. This is what the First Amendment was designed to protect. Our ability to watch what our government is doing and share our opinions with each other about it, because that's what gives us the power to change it. So this is the most protected speech in the United States Constitution that we're engaged in by talking about this trial. And that's why, big part of why this is such an important conversation to have. I mean, it just touches on so many things, law enforcement, the duties that they have, the courts, fairness, the presumption of innocence, and, the practical challenges we have of being able to implement that. Very, very important parts of our criminal justice process. Freckled Gemini, we are all so grateful for your brain, empathy, passion, efforts, stamina, and badassery. Thank you. Thank you very much. It's very nice things to say. Cookie Harris, P.S. Enjoy every bit of a good old sleep-in Sunday. I can't wait. I mean, I've said it over and over. I can't wait. I'm just going to, point out that when you reach a certain age, it gets harder to sleep in. Like, that's been one of the challenges. It's like your clock kind of starts to get fixed. And I notice it at home, you have a little bit too late of a night or something like that. I can't sleep in like I could when I was a kid. So I have fingers crossed that I'm not going to be cursed with that tonight, that I'm going to be able to sleep long and late, that I'm so irregular in my schedule here anyway, that I'll just be able to get a good reset. So I'm looking forward to that. Hospice Jess, Delphi needs a turtle boy. Yeah. Yeah, somebody who can dig into a lot of this stuff. I mean, there have been a lot of folks, doing a lot of work on this case. I always point to All Eyes on Delphi as just a fantastic resource for the case history here. It's comprehensive. You want to read the court documents, they're all there. But it's also very accessible because it's been processed in a lot of different ways to kind of help you break it down into timelines and into sequences of events and things like that. So a lot of good work like that is being done. But yeah, most of the kind of investigative stuff that's happening has really just been grassroots. A lot of people in my comments with comments about, things that they've seen and heard, and people, sending me messages about other information that they have and stuff like that. So yeah, I can definitely see how that could help to reveal a lot more of just the scope of what's going on here and what we're seeing. Julie B is now a YouTube member. Welcome to the channel, Julie B. Jen Helmich Sackett, thank you so much for all your hard work bringing this all to light. Did the camcorder recording Alan with his attorneys have audio for them to listen? I believe they claim that it was only one time and that nobody did listen to it. But yeah, it would have had audio. These camcorders all have audio. I'm not aware of any way to turn the audio off. Yeah. I would expect that, yes, they recorded the conversation and included the audio part. To Truth for Liberty, to check and balance, the public must have access to stuff that may hurt the individual parties involved with a case. Not a good choice, but choosing the one that allows oversight of government is number one. Yeah, I mean, this one is a tough one. I do. I get it. That's why I think it's going to be very, very hard to meet that standard for getting these sealed if they don't fall within that specific exception. I do. I understand this. And at the same time, I do have enormous sympathy for Mr. and Mrs. Allen and their family, their daughter, everybody who knows and loves them and cares about them, their family. It would be horrifying for this to be out there in public. And when none of this is his fault. It's the re-victimization angle again. If he's not guilty, and at this point, I don't believe he did it. We've seen the entire state's case. Certainly don't think they proved it. And just really not seeing any good reason why he would have done it. Not really seeing a good explanation for how he did what we've seen. I don't think he did it. So he has been terribly victimized. The whole family has been terribly victimized by this whole process. And that's, that's out there in public through no choice of his. That's a re-victimization. So I really do struggle with this. But I understand the idea that sometimes the public interest is greater than the individual. I really do. It's just hard because I'm not a cracking eggs to make an omelet kind of person, I'm very much a proponent of each individual human's dignity and agency, and so I don't like the idea at all of sacrificing somebody to the greater good. That's a utilitarian type of mind frame, and that's not a kind of philosophical mindset that I adopt. I'm more of a Kantian. I'm more deontological. Anita E., the closer a nerve is to our brain, the faster it sends calming signals. As we touch the face, apply pressure, chemicals are released, which calm us. That's very interesting. Yeah, I wasn't aware of that. But I mean, it is calming. It is very calming. You can just do it yourself. And yeah, it's comforting. Jennifer Ferguson, don't forget to make your clocks fall back tonight. Oh my gosh, thank you for the reminder. We get the extra hour on Sleep In Sunday. It isn't just Sleep In Sunday. Oh, it's the blessed Sleep In Sunday where we get extra time. I totally forgot about that. It's totally off my radar. So thank you for that reminder. I'm looking forward to that extra hour of sleep, assuming that I can actually get it given my age. Love and Limes, do we know any more about the trail cam video? We've heard nothing else yet about the trail cam video. I do wonder if it's going to be possible for us to see it. I wonder if we're going to see it. I wonder if we're going to have somebody else with information about where exactly that trail camera was and where exactly it was directed, what its field of vision would have been, just to help us sort out, like, okay, if we're watching this, what is this really telling us about that person being present there? Would like to see more of that from the defense for sure, if that is available. Analytical Blarney AB, a mere special ed teacher. There's much wrong with this from psychological issues, etc. I can't justify any of this and join you in your uncomfortableness. Yeah, this is appalling. This is really, really appalling what's being done here, and how they took a man that was fragile, that they knew was fragile. They knew he'd had a crisis event that led to him being hospitalized. They knew that he had these serious issues. They knew it from the outset. And they still subjected him to this treatment. And at a certain point, the choices that people make, it's hard not to see them as being intentional. They knew when he came in. And they still subjected him to these conditions that you expect them. I mean, their own policies anticipate that people are going to deteriorate in these conditions. That's why they have to have these daily check-ins. And the whole idea is, well, we're supposed to be able to intervene, things get bad, but How long was Mr. Allen going downhill before they intervened? And what was their intervention? Is to drug him, not to remove him, put him in the mental health unit. At some point, just all of these decisions, it's hard to come up with an innocuous reason. It really is. Why is this particular guy getting accepted from the rule, the limitation on solitary confinement? 30 days of solitary confinement, no more. Jody J, what was your overall feel from the jury combining all these reactions? I know it's hard to predict, but what's your gut intuition? Thanks for everything, Andrea. My gut intuition is that the jury was absolutely horrified by what they saw. Horrified. And the big tell for me, the big giveaway, the reason why I thought this escalated to anger was that juror who leaned forward and gave that long look to Mr. McClelland. This juror has not been a spectacle in any way. Very unobtrusive, very much in the background. And so this was an aggressive type of action. It's extremely obvious. It's very intentional. And it was showing, I'm not afraid of you, and I don't care if you see me staring you down. And it just reads like this was a call out. This was like a visual, a body language call out. Disbelief, the shaking the head. No. Shaking your head means no. I cannot be seeing what I'm seeing. I cannot be seeing this. That's my gut reaction of what the impression was. And that this was understandable and sympathetic because other members of the jurors that know that he's having these reactions, they're checking in on him. They're making sure he's okay. They're not blowing him off like, just exaggerated or, totally blowing this out of proportion. No, they're legitimately making sure he's okay because they're just as horrified by what they're seeing. They just aren't expressing it quite as openly as this one was. So that's my gut takeaway. I think the jury was appalled and horrified and in disbelief, and it made a strong impression. That's what I feel. Brandon McRoby, you, Lawyer Lee, and Bob and Ali Mata should have a joint live when the jury goes to deliberation to discuss thoughts on the case. I really hope we can do this. We've kind of talked about just briefly about the possibility of doing like a roundtable kind of thing. I think it would be great. I really do. I don't think there's been other lawyer observers in the courtroom. If they are, I'd love to have them on too, regardless of their perspective on the case. I think it's helpful to like I said, have that background, have that just little extra bit of insight about what the process means, what the things that we're seeing means, the significance of the decisions and so forth. So I think that would be a lot of fun. And I also kind of hope we get to do that. Linda M, thank you, Andrea. And clocks turn back 1 hour. Yes. Celebration. Thank you so much for that. Danny Deepak, your coverage has been incredible. I keep waiting for the gallery to get guillotined. Guillotined. That's a good one. Yeah. I mean, the law has not been much of a restraint to her in my perspective. But there are certain things that are just so obvious that for her to ignore that, even she would know it would be a career-ending reversal, to make that kind of decision, to boot us all out of the courtroom without, individual basis, stuff like that. Yeah, no, there's no way that gets upheld. There's way too much authority on that. I know that she would, I believe that she would love to. I really do. She would be much happier if none of us were there. except for, her new pets, the credentialed media, who are reporting the highlights, as best as they can understand, but not necessarily, from my perspective, really presenting a full and fair view of what is going on in this trial. The selection of what you choose to report is in and of itself, a judgment. So, I've talked about this before. I'm kind of skeptical of journalism in that sense. This idea that they can keep themselves out of it anyway. You can't. It's not human. It's not human. Every human has biases that we have to be aware of. Every human is going to reach judgments from information that they're exposed to. That's what our brains are evolved to do. That's what makes us so different from any other animal on the planet. So we're going to do that, and to me, it's just a fiction to think that we're not. And so the media is doing that. It's just that they happen to be doing that in a way that is corresponding with, how Judge Gohl would like that information to be out there. Because now the same thing is happening on the public level. They're consuming the information from the media. They're forming their judgments on it. And if that information is pre-select to make it look like there's a really strong case against Richard Allen, then that's going to feed a public analysis that, he must be a really guilty guy, a really terrible guy to do these things to these little girls. And then all of this stuff, the defense case, even the parts of the prosecution's case that, aren't necessarily that helpful to the state, but have been elicited, like, for example, Dr. Wallace's testimony and all of the surrounding circumstances about these particular statements, When you Nancy Grace the case, none of that matters. You just get the parts that you need and you run with that, and that's going to further a narrative. So that's how Judge Gohl has handled this. She would love to boot all of us except for her little media pets. But that would be, even she would understand. I think that would be a bridge too far. That would get her a smackdown, and that would likely be career ending because it is just too blatant. It's too blatant. She's got to try to keep it under the radar, cross the line, but not so far that it's going to get her wrist slapped. She's not a dumb woman. She just knows how to play the game. Wiggly 95. Why didn't the defense ask Superintendent Doug Carter why the FBI was asked to leave? Seems like a missed opportunity to me. Well, it's one of those things where if you don't know the answer to the question, you cannot ask it, especially with a why. I don't know if they know the answer. It may have come up in the deposition, and it may be that he's got some excuse for it. Oh, well, it was just weird, and so then that's going to diffuse the impact that what you were able to just elicit has. You asked them to leave, and you asked them to return all their materials. Like, lose my number, give it all back. Don't do anything on your own. Make sure that we have exclusive custody and control over the investigative documents. I mean, that's very impactful information. And so if that gets diluted with just some excuse about, there's political stuff, we just found it very hard to, coordinate, and there'd been some incidents where maybe people didn't see, and they were fighting, and we found it was detracting from the investigation. So we thought it would just be easier, comes up with something like that. It just really deflates what you've just accomplished. But I would point out, Mr. McClellan could have done that too. He could have done that too. So I think it's just a situation where there wasn't necessarily a huge upside, because this is not your witness. This witness is not friendly to your position. You can't expect him to give a friendly answer to an open-ended question like, why did you do it? He's going to give a self-serving answer. And a self-serving answer is going to benefit the state and not the defense. That's my read on it. There's no way in a million years, unless I knew what his answer was already and could pin him down in his deposition, and it was something I wanted the jury to hear, No way, no chance at all. I'm asking that guy why he got the FBI off the case. Love in two lines. Last night you said the blood from one of the girls was missing. Does this make you think it was some kind of occult or sacrificial killing? I'm having a hard time accounting for the blood when it comes to Abby. It just doesn't seem like there is enough of Abby's blood there for this to be consistent with her being killed in the location where she was found. And the pattern of the blood, it's just seeped into her sweatshirt, but there's actually very, very little on the ground underneath her neck. It just doesn't look right, especially when you have that with comparison to Libby and just the massive pools that are around. And even Libby has pooling of blood under her neck, despite there being like all this other blood around the scene. So, we haven't had testimony about that, not at this point. I do wonder if that's something that the defense has in their toolkit. Give us some more analysis about this crime scene, because we know it's a problem and they haven't been able to explain it. Abby's hands being clean, they haven't been able to explain that. So there is something off here. And I don't know what the explanation is, but I certainly don't want to rule out this defense theory. I don't want to rule it out. I don't know that necessarily follows, from this type of conclusion. I think it's also very possible Abby was not killed where she was found. She was killed somewhere else. And whether that someone else might be like in the river, which could possibly account for, the wetness of her clothing. Whether she was, as the defense has been suggesting, taken from the scene. And that's why the phone came back to life, pinged back to the tower at 4 something in the morning the next morning. Not because of like any sort of magical thing that the phone did, but just because it came back into cell range or somebody turned it back on. So I think those things are possible without this being a ritualistic or cult killing or something like that. I think an off-site killing is very plausible. And it just seems to correspond with the lack of noise, lack of noise. Nobody heard anything. And, these girls, they were mortally wounded, but they still had their airway. Just hard to think with how that sound carries in that canyon, having been there. Seeing the Russells, how just a tiny little like chipmunk, scurrying around on those leaves. I mean, you hear it from a ways away. All those things together, offsite does make a lot of sense. And if this trail cam, even if the trail cam is a searcher, it does seem pretty hard to believe that you were very concerned about the girls being in this area, being near the water, being near the bridge, being lost in the woods, and yet just conveniently the one spot you didn't check is the spot where they were found. It's just very hard to believe that. That's my take on it. So I'm more inclined to think, I guess, that the explanation for why that crime scene is the way it is because Abby wasn't killed there. I can buy that Libby was killed there. I can buy that Libby was killed there. But Abby doesn't make sense. So Starlight Selenite, Andrea, thank you for your knowledge, time, dedication, and heart. We appreciate you so much. I appreciate all of you guys. It's made all this worthwhile. The fact that it matters so much to so many people, that you found it to be a value add, that's all I want to be. I'm just a person that has been doing this job, and so I have insight because of it. And I recognize that people that care about what happens in the courts, find that valuable, that they don't have that access, and it's just very helpful to be able to understand on a deeper level what is happening, what is the significance of what we're watching. And that's all I've really ever wanted to do, is just share that with people. And the fact that it's been rewarding like this is, it's mind-blowing to me. It's not what I ever contemplated. I'm still kind of getting, I'm not used to people on the street. Hi, Andrea, I love your work. I'm not like, it's cool. It's very cool, but it's like, it's just strange, because of course I don't see myself that way. I'm just a person doing a thing, but it really has been wonderful. So Belle M. Hi, Andrea. Do you think the jury being sequestered may benefit the defense, as they may be able to empathize with Rick's situation a bit more? Yeah, we talked about this a little bit earlier. I do think it makes it easier, especially if the defense can tell the story of Rick being taken away from his family and his habit and his routine and his comforts and everything that he knew, and having to be separated from them, cut off, and deal with this foreign situation, all by himself, put in this new context that he doesn't understand, with rules that he's not used to following, and having to learn a new way, of living. And now imagine what it would be like, if it's this severe, and when you don't have a lot of hope. Like, imagine yourself losing hope that you're ever going to get to go back home. That's really the step the jury needs to make, is like, you get to go home, and you even have a pretty good time frame for when you get to go home, and you don't even have to question really that you're going to be able to go home. So what if you did? What if you thought, I might never go home? How might that affect you? Sarcasm FF, you're amazing. Did they find any of the bloody clothes or anything the suspect was wearing? Would love a collab. The Tilted Lawyer, Omar Serrato, at some point in the future on this case. Thank you so much. Enjoy your Sunday of rest. Thank you. So bloody clothes or anything the suspect was wearing, not to my knowledge. Certainly not from Rick Allen's property. Of course, they searched it, 5 years later. They want to suggest they found the actual items, the blue Carhartt jacket, but they weren't able to recover any type of usable evidence from that came out in trial. Now, I will point out that one of the parts of this case that sits very poorly with me, and I pointed this out before, most of Abby and Libby's clothes, the ones that were not, put back on Abby, most of the rest of the clothes, with the exception of a pair of underwear and a sock, they were found in the creek, kind of all entangled in the same place. And there with them was what has been described as a green handkerchief. And there's been no attribution of this item. Nobody has claimed it. Nobody has suggested that this was something that the girls had with them. This appears to be the item that, out of everything that's been recovered, has the greatest chance of being something that originated from the killer. That the killer brought this handkerchief and disposed of it because maybe this is what I keep coming back to. Maybe this is what was around Abby. This was like the gag or whatever. Or just a restraint, something like that. But it was disposed of, along with all of these other items. That had to be for a reason. And so what doesn't sit well for me is that this one particular item is the one thing from everything that was recovered from the river that they didn't test. They didn't do any testing on that. The explanation for this was, actually, the explanation is likely that she wasn't asked to test it. But that in general, that items from the river, they had a very high risk of interference. You wouldn't get good results, DNA results, because there's just too much stuff, too much contamination from the water, from bacteria, from debris and stuff like that, that's going to mask whatever DNA you're able to get. So, we heard about that. It's a low probability proposition to test the items from the river. And yet they tested every single item from the river, with the exception of this one thing that seems, out of all the possible explanations of all of the things, this one has one of the highest likelihoods of like maybe belonging to the killers. It's hard for me to wrap my head around that one. So no, they haven't found bloody clothes or anything the suspect was wearing. They had a, potential item here, it seems like to me, but they didn't test it. So if you don't go looking for stuff, then, it's not really all that surprising that you don't find it. Summertime. If a mistrial, do you think the DA would retry Richard Allen? Thank you for all you do. I'm so grateful for your detailed coverage. Yes, I absolutely believe that they did, that they would. They have doubled down on this already so far. With this crime, and with how far they have gone in insisting they've got it right, they've got the right guy, there's no backing down. They can't back down. They can't just be like, oh, well, it'll be way too expensive. And, they would have to backpedal. They would have to backpedal and acknowledge, well, the jury not being able to reach a verdict reflects that there are, perhaps significant doubts about Richard Allen's guilt that, the case isn't able to overcome. And as soon as they open that door for, we acknowledge maybe Richard Allen didn't do it. Well, now you have to answer for how you treated him. There's always going to be some people, I am not among them, who have the attitude that if somebody is like a terrible person, a monster person, a predator, that any sort of inhumane treatment of that person is justified. There's always like, somebody gets arrested for terrible crimes, against children, and you get prison rape jokes. I mean, you don't even have to be arrested for that type of crime. Prison rape is like a joke. It's not a joke. Lock him up, throw away the key, let the guards in at him. People can take a very inhumane attitude towards people that they believe are guilty. And so as long as people think Richard Allen is guilty, there's a certain number of people who will think, well, then he deserves this. He doesn't deserve any better than this. And that's the only way that the state can maintain any type of moral standing, which again, I don't agree with. And I think a lot of people don't agree with, even if he is guilty, which I don't believe, but even if he was, you don't treat people like this. We are different from the monsters. That's the entire point. And so if we become monstrous ourselves, we lose our moral standing and our justification for doing all of this in the first place. And so it's no longer justice that's being done. It's just power and vengeance. So I think they're stuck. They're in a box, because if they admit the possibility that Richard Allen didn't do this, and that it's such a strong possibility that we're not going to retry him, then there's accountability. They have to accept accountability for what they did to him. And I don't think they're interested in that. I don't think they're interested in that. I think that's exactly why they have come at this so hard, why it was August of this year. They went out to develop this, what has become the critical now piece of evidence in the case, the white van, the unique fact that only Richard Allen would have known. They didn't even get this information until 2 months before trial. And now it's like the linchpin of their case. It's what they closed on. It's what they wanted the jury to hear last, to stick in their minds, the white van. And they didn't even have it until 2 months before trial. It tells such a story to me. They never thought it was going to go. They never thought it was going to go. So once they realized it was going to go, oh shit, better buckle down because this stuff's weak. We need to find something that we can strengthen it up. And so they went to Brad Weber and had an unrecorded phone call with him by the investigator who has just demonstrated every type of shady and dishonest behavior. I mean, we can read between the lines there. So yes, I think they absolutely would retry him, and they would continue to retry him until they got a verdict. Wouldn't even matter how many times. Julie B., what's your feel on the jury today? I feel that the jury was deeply affected by what they saw. That's my feeling. Missy's Angels, in my opinion, transparency should always outweigh dignity. We need to hold everyone accountable, and the only way is not to shield the truth, no matter how horrible. I know. I understand this. I really do. I guess all I can say is that my preference in this situation would be for there to be a self-sacrifice to give that transparency, you know. That would be my preference. This is a hard one for me, you know. Every person matters. La Kong Express, I'm giving you an extra hour to sleep. Thank you for that. I'm very grateful for it. Ashley Nudo, Andrea and Jeff, of all the trial coverage you reported on, has there been any other case you received threats? We are privileged to information from a well-versed attorney who, like myself, wants due process and justice. I mean, yes. Like almost everyone I've talked about. There's somebody out there, as soon as you have an opinion, that wants to threaten you. Delphi Heard, you know, was the introduction to that. These crazy, abusive people who support Amber Heard and you know, make themselves willfully blind to the fact that we all heard her on audio recording engaging in acts of abuse against him, verbally abusing him. Made it crystal clear what the dynamics of that relationship were. You know, the evidence is what it is. And so when people can't argue with the evidence and they can't resolve their dissonance, you know, cognitive dissonance, when the evidence doesn't conflict with your view, doesn't correspond with your view of reality, you try to reconcile it. And if you can't, creates an emotional response. People get angry. And so that's a big tell, you know, with internet stuff online. When people get angry, when people get accusatory, when people get, you know, ad hominem, name calling, stuff like that, it's just because they don't have a factual response. So all they have is their feelings, and that's how they're expressing them. So yeah, pretty much every case I've ever covered. Tonics, greatly appreciate your moral compass. Well, thank you. It's you know, again, it's you know, I feel like this sort is like baseline. You know, being moral people, it shouldn't be a lot to ask. You know, I don't feel like that's unique or special. I mean, I recognize that there's lots of immoral people out there, but lots of us out there are very moral and have good, strong moral compasses. And so it's part of what I appreciate about having such a big group of like-minded people around. ERP7 became a YouTube member. Welcome to the channel. Scorpid Black Dragon, defendant, you try the facts. It is a fact. Richard Allen was arrested and placed in solitary confinement for 13 months. It is a fact. Richard Allen mentally degraded. It is a fact, etc. Yeah, I mean, that's certainly an approach to be able to present it. Certainly approach to be able to present it. Distinguish between, you know, what's a fact and what's not a fact. Let's distinguish when One thing I always like to do, it was one of my favorite ways to handle a closing statement. Every case is different, and it just depends on your circumstances. But I would always take extensive notes during the prosecutor's opening statement because I would often structure my closing around that. See, during openings, here's the commitments that you were given. Here's what you were told the evidence was going to show you. And so now we're going to work through these commitments that the prosecutor made to you, because the reason why we have the opening statement is to give you a fair view of where the trial is going to take you and how it's going to lead you to the conclusion that that we want you to reach. And so here's the commitments the prosecutor made. Now let's look at the evidence and see how well it led up to the, how well it followed those commitments. And you could do similar things like that and like this structure as well with this case, because so much of what they told you turns out it's not fact. It's not fact that Richard Allen said he took this alternate route to get to, it's not the fact that Richard Allen told you he parked at the CPS lot. It's not a fact that it's Richard Allen's car that's on that video. It's just opinion. And so much of what the prosecutor presented to you in an opening statement as fact is not. And the evidence has shown you that. Especially in a case like this where, prosecution has a heavy portion of the responsibility for what happened to Mr. Allen. So it's just a small way to hold the prosecutor the tiniest bit accountable for those decisions. Karina Cameron, 2 out of the 3 investigators that lean towards the Odinism theory haven't had the best of luck publicly, since publicly stating so. 1 murdered, 1 arrested. Yeah. There's so many like side stories and rabbit holes surrounding this case and the investigation. I'm interested in following the Todd Click prosecution. I'm interested in following that. I kind of doubt it's going to be any more transparent than this one has been. But yeah, I read the probable cause. I read the probable cause for that. Be curious to see it substantiated. I've worked in that system. I've worked in the CPS system. And I've worked with the clients. And the thing is with, with a lot of people in that position, you're often dealing with issues of mental health and issues of addiction. These are probably the most common things. Physical abuse is common, but it's often related to those other things. And so these can be situations that are associated with an awful lot of denial. Certainly addiction. Pretty much, like a characteristic. And so you hear a lot of excuses and explanations and things like that are not true. It's just the reality. So I don't know the veracity of anything that's in that probable cause affidavit. But yeah, I'm interested in seeing how that plays out. See if they're able to substantiate it a little bit better than they were able to substantiate the probable cause affidavit that they filed as to Richard Allen. Suyan, do you think the defense will bring the subject about infertility by vasectomy or something else to explain evidence of likely semen? Also, what should we expect from the defense in next hearings? Love you. I doubt that they would do this because it's in the defense interest to not highlight the possibility that those presumptive positive tests were not false positives. They don't want to suggest that there's corroboration that the girls were raped, because that was included, as part of Richard Allen's confession. Now, again, it's inconsistent. Wanted to, tried to, or whatever is not consistent with like actually achieving it. But it's just a little too close to home and too close to comfort. I mean, the reality is these presumptive tests, they are presumptive. It means they're not, you can't rely on them for 100% certainty. There are a lot of different reasons why, just depending on the type of the test it is. It's often a prostate-specific androgen test that's done. And there are conditions that women can have that will, trigger that test. Is basically for a protein. And there are conditions that women can have that will trigger that response. That it's not a true reaction to a presence of seminal fluid. So that's why, if they want to present it in court, they need to do a confirmatory. And that wasn't done. So false positive is going to be where the defense wants to go with it. I don't know, again, without specific information about the test, I don't know like what the false positive rate is. Generally with PSA tests, I want to say they're somewhere in the ballpark of like 2 to 5%, which is fairly high, for a chemical test. But it also, it would seem to make it more improbable that 2 tests, both of them would be a false positive. But still not out of the realm of possibility. So I think the defense is likely to stay away from that altogether because they don't want to open that door. They don't want the jury to be thinking, oh, is there evidence of rape? And does that corroborate Mr. Allen's account of what happened? Beer 30 Lacrosse, does this experience give you inspiration for other avenues of fighting justice? I mean, yeah, it's really motivated me as far as the transparency battle, and the need for these things to be public. I've just never seen a situation this extreme, so I don't know how many opportunities there are going to be to fight this fight because, most courts are reasonable and recognize that, yeah, your public access, it's protected by the First Amendment, and it's a preference. It's transparency is a product of all kinds of different public records acts and things like that. So it's rare to have it so extreme like this. But at the same time, federal courts, we don't have cameras in them. There's like a few, they're doing pilot testing now for cameras in some federal courts. It's like a test project. But by and large, federal trials don't get televised. And ultimately, it's discretionary. Most cases that do allow it, it's discretionary with the court. They don't have to let cameras in. But it really does steel my spine. It's something I've advocated for a long time. And this case has really, really emphasized how important that is, because even with the audio recordings, you guys didn't get to see. You didn't get to see the little smirks on Mr. Mullen as he's sitting up there giving those answers that he thinks are so clever. You didn't get to see the little side-eyeing of the jury. You didn't see how people reacted and shifted in their seats and the expressions that they made and stuff like that. And that it is a really important part of the trial process, being able to see that. So I would say that is definitely a big inspiration that I've gotten from all of this. Is it really has grown my motivation to be an advocate on that particular issue of making sure that trials are something that can be seen. Renee Mitchell, someone commented on Vinnie Politan's stream and said they worked at Westville and bragged about how every time he went by the solitary area, he would yell at Richard Allen. Humans are cruel. Thank you for this coverage. Yeah, and prison is a very, very cruel place. It's a very cruel place. And sometimes it's a little bit hard to distinguish between, are the monsters on that side of the cell or this side? Because it's a very, very dehumanizing environment. And if you have a wealth of human compassion and empathy and care, you're not going to survive there. You're not going to make it there. So it selects for cruelty and callousness. Peggy O, if you have to make a protest sign, what would be your slogan? Oh my, I don't even know. Like, the slogans that I've been seeing are so clever. Like, they're so clever. I don't know where people come up with this stuff. So we've seen the no cameras, no wonder. God, that's good. That's so good. So clever. Another one that was out there today was saying, shame on you, Indiana. This is goal shit. Like, you guys, I don't know where you come up with this stuff. It's just so clever. It's just so clever. So I would have to really brainstorm it to be able to come up with something that I would feel like could hang with the signs that are already out there. Yeah, I don't want to knee jerk something. Let me think about it. Let me come back to you on that. Let me give it some thought and see if I can come up with one that would really justify being on a sign and displayed like that. Bowie Girl, can the prosecution pick which confessions are brought into evidence? If there are recordings of Richard Allen stating that he shot the girls, would they be able to leave that out and nobody would ever know? Yes, they would. This is the whole rule of completeness argument that Mr. Rosie was making the other day. When he was arguing that the first phone call in the series of 3 phone calls that were made back to back on, I forget the exact day, but the very first one to his parents, I think it must have been April 3rd, because it was the first of the confession calls that he made to Kathy. And so just before that, he had been on the phone with his parents and, yes, talking about how he's innocent and, didn't do any of it. And so the defense is arguing, to put it in context, you need to show the jury the whole thing. You can't just cherry pick out these pieces. And the judge says, well, watch me, watch me. Mr. Rosie is absolutely right about what the rule says. And the judge says, I think I'm looking at it a different way. And so I'm not letting it in. So yes, Richard Allen's own statements, when he makes them, when he offers them, they're hearsay. And so unless they fall under some other type of exception. Now, again, this is an obvious one that is not being offered for a hearsay purpose. Nobody is offering the statement to argue that Richard Allen actually shot the girls. That's the entire point. That's the entire point. It's being offered to show that his state of mind was such that he was delusional and he was reporting things that were not actually real. That's the entire point. But that hasn't gotten them anywhere, so far with the information that they've tried to elicit. And so it appears that we are just getting a pretty hard line rule that if it was set out of court and you want to use it, it's going to be hearsay. So yeah, it looks like the state is going to be able to do that. If we were applying the rules with a fair-minded judge, then I think it would be possible, but that's not what we're dealing with. Yep, think it's very possible that if he said something like that, the jury is never going to hear about it. Mac Lawrence, onlookers were very concerned that Richard Allen, based on the PCA, since it was released, felt really weak, and the more we heard, it's clear how little there is. In your opinion, is Richard Allen acquitted? I know I'm acquitting him. It's so hard to predict an acquittal, because it's so rare. But this case, it really is. It's extraordinarily weak. And it hasn't been helped. The state really hasn't helped itself with this case. Like it's really like the case has just gotten weaker the longer it's gotten on, no matter how hard they struggle. And in part, it's because it's their own efforts to try to make it look stronger that are revealing how shady and underhanded they're being. And if you have a good case of guilt, you don't need to be shady and underhanded. You can just put on your case and let the evidence speak for itself. And that hasn't been what's happened here. So it's always just a question of, is the jury going to see things the way that I see them? I don't know. But I guess I'm going to have faith that they do. An acquittal is very, very hard to predict. I think a hung jury is a very real possibility. I think a hung jury is a very real possibility. There just may be people that are hung up on certain details. They just can't get past. Other jurors can get past it, but you reach a point where people aren't willing to compromise anymore. So I think that's a very real possibility. Acquittal, I want to think so. I really do. I really do. I certainly think that's the just result here, but it's very, very hard to predict. Lisa Shelton, did you get your package today? I hope you enjoyed it. Clothes were just some of my favorite things. I hope you enjoyed it. I did so much. Thank you so much for that, Lisa. And I hope you don't mind that I posted a little picture of it on my Instagram and my stories. It was just such a nice gesture. I really appreciated it so much. So yeah, very, very grateful to you. And I really enjoyed getting to meet you, and glad that you were able to have that experience in the courtroom. I think a lot of people that have been able to make it and have that courtroom experience, it's been eye-opening. It's a different process being in there than it is just hearing the accounts after the fact. So thank you so much for that. I really did appreciate it. We have Bex as a new member. Welcome, Bex. We have Tyler with a super chat. Thank you. Kathy, your realtor in Jersey, you have opened my eyes. Thank you. Well, I appreciate that. I mean, that's big. That's big. Vertigo vet, jail is tough. He admitted to being there, confessed multiple times, and really resembles Bridge Guy to me. In your opinion, has there been strong evidence that he didn't commit the crime? I think the strongest evidence that he didn't commit the crime is just the biggest one is the way that the descriptions of Bridge Guy, the witnesses, the eyewitnesses who claim to have seen who they're calling Bridge Guy, have no resemblance to him whatsoever. So there's a big discordance there. Obviously, none of his DNA at the scene, no connection being found, nothing. We had these internet searches, but like nothing. To me, these are all innocuous. They're just types of things that are, anybody could be searching stuff like that. A whole bunch of them looks like he's trying to remember like a movie that he watched. He can't remember the name. And so you try to describe it in the Google search bar, see if it'll come up. The peculiarity of the crime scene, it does not look like just an ordinary run-of-the-mill crime of opportunity. This is problematic for me. No explanation for the phone activity. The inconsistencies between the, so-called detailed confession that he gave and what actually transpired, the racking the bullet on the bridge, but no account of how a bullet would be not at the bridge, but in fact down at the crime scene. What we saw with our own eyes from his confession, how this doesn't look like a guilty guy. It doesn't. Not the confession, the interrogation. The interrogation. He doesn't look like a guilty guy. He looks like a very normal person who is getting increasingly frustrated that people aren't believing him when he's telling you he didn't do it, because he sincerely believes he didn't do it. Nobody else in... I mean, this is the issue I have with him having a resemblance to Bridge Guy. I mean, Bridge Guy is very innocuous. Bridge Guy could be lots and lots and lots of people. And they had tens of thousands of tips, everyone and their parent. You know, my neighbor looks like Bridge Guy. My son-in-law looks like Bridge Guy. All of these people look and sound like Bridge Guy. And yet not a single person ever was like, that guy at the CVS, he kind of looks like Bridge Guy. Maybe he's Bridge Guy. And then just the cherry on top of it is the law enforcement shenanigans. You know, there's just so much dirty business associated with tying him to the case, the way that they distorted what he said in his interviews. They misrepresented it and continued to do that on the stand. And his statements, they continued to misrepresent his statements on the stand, claiming that he told his wife, oh, if it gets too bad, I'll tell them whatever they want to know. No, he didn't. He said, I'll tell them whatever they want me to say. So these things are all just big tells to me. You know, these are proof that he didn't do it, because if he did do it, you wouldn't have to be doing these things. You would have the goods. I don't think they have the goods. So if we look like, if we kind of put the evidence in piles, you know, the things that point to Richard Allen and the things that are inconsistent with it being Richard Allen, my view, the pile of it's not Richard Allen, a lot higher. A lot higher. But it just depends on, you know, it depends on your perspective and what you credit. If you put weight in these confessions, then yeah, that's going to have a lot of weight. Seeing the context and the circumstances and the behavior that was being documented and hearing the phone calls and how they went and this, you know, what he sounded like and all of that. No, they don't carry a lot of weight with me. They don't. But that is just me. You know, I know other people see that differently. But false confessions are just a massive, massive issue in wrongful convictions. It's been that way for decades. Something like 30% of the exonerations that we've gotten since DNA, you know, old cases where people spent decades in prison, and then there's new DNA evidence that comes out that exonerates them. Something like 30% of those cases involve a false confession. So it's something that I can understand, you know. I think everybody has a breaking point. Everybody likes to think, you know, oh, if the Viet Cong captured me and I was in their prison for you know 10 years, I would stay strong. I would resist. But you just don't know until you're in that situation. And I tend to think everybody has a breaking point. We know that from like you know, the waterboarding interrogation, the harsh interrogations and stuff like that. It's not particularly helpful at getting you good information. It's just useful at getting people to tell you what they think they want that you want to hear, so that you'll make it stop. So the confessions don't carry weight with me. The bullet doesn't carry weight with me. That analysis, it's, you know, it's junk science. It's junk science. So now all we're left with is, you know, way back in the day, he said he was on the bridge, you know, at the time that would be the right time. It's just that nobody else saw him there at that time. And the people that they were seeing out there at that time don't look anything like him. We don't have his car there. So I don't think there is very strong evidence of his guilt at all. Lisa Shelton, I meant to ask, you think things from this case will ultimately end up in the Supreme Court? I would hope it doesn't get to that point. You know, my hope is that he's acquitted by this jury and this is the end of it. I mean, that's my hope, because my concern is that if he is convicted and the longer this goes on, I just don't know that he's going to make it. I really don't. He's already so fragile. And I mean, that's just such a massive blow, such a loss of hope. And it takes a long time to get up to the Supreme Court. So I would hope not. But if he got convicted and he appeals and he's not successful on appeal, he's going to try to take it up to the Indiana Supreme Court. And they may or may not take it. And then he may or may not try to get it up to the U.S. Supreme Court, on federal constitutional issues, like his right to confront and cross-examine witnesses. Very unlikely, to make it to that point. But I don't want to be thinking along those lines. I don't want it to get there. Mac Lawrence, you are great. Isn't the judge required to tell jury repeatedly what reasonable doubt is? It's a high bar. Will Gold do her duty to tell jury? I expect Gold to follow the pattern jury instructions on this. She has already given them preliminary instructions where she tells them what reasonable doubt is. She describes it. And so it's not, unprecedented. The jury's already heard it. It's typically in the closing instructions as well. And so I expect they'll hear it again as part of just the standard script that's read when the case is submitted to them. Kokomo, Indiana, thank you so much for covering this. I missed about Weber. Is he in Texas or not testifying? So the Brad Weber testified on Thursday. I think it was Thursday last week. And he was subpoenaed by Mr. Baldwin at the end of his testimony. While he sat there on the stand, Mr. Baldwin walked up and handed him a subpoena. And so the defense is clearly holding out the option to call him back to trial. That means he has a legal duty to appear. And if he doesn't, he can be in serious trouble for that. As far as the FBI agent goes, the one that they're trying to get on the stand, all we know, we've been told that Monday, Tuesday, Wednesday next week, he's in Texas for the election. That's his assignment, his duty assignment. He cannot get out of that. It's important. And that otherwise he's got health issues that prevent him from being able to travel. And so that makes it difficult. That makes it difficult to anticipate if he's going to be able to get back to testify in person before this trial's over. I mean, we know he's getting to Texas somehow. I don't know how he's getting there. But have to find his way back. And then again, he'd still have to be permitted by Judge Gold to testify to impeach Brad Weber when she seems to think that Andrew Baldwin didn't set the foundation for that impeachment correctly, despite what the rule says about that. Kim Young, I feel like I could sit for the bar after watching you past weeks. Have you ever thought of running for Judge Supreme Court? I get this question a lot. It's not something that I want to do, at least, not at this point. And frankly, at this point, having said everything that I've said on YouTube, put myself out there and stuff like that, I honestly don't know that I could get elected, which is fine. It's a political position, and there's a whole side to that it's just not. It doesn't suit me. It's not consistent. It's just not, my personality doesn't really favor that. So I don't think that it's a really good fit for me. I think I am better as an advocate. But I don't like to say never. I don't want to rule anything and everything out. Lisa Shelton, what did the judge's face look like today watching those videos? Last question. So like I said, one time I caught her, watching them intently, looking down her nose. I did catch her another time looking at them just a little more straight on. But she just has her baseline expression is a little bit grim. Her resting face is, with the frown. She's got a frown resting face. So she didn't, show anything that I saw. But granted, I only looked at her a couple of times, trying to pay most of my attention to the jury. Nick TTT, Judge Gold said that her inspiration is Atticus Finch in an interview. Oh, how far she has strayed. When fairness falters, justice itself stands trial. Yeah. Yeah, that's one of those things that I read that in hindsight, and I wonder if it was ever true, or if it's just the kind of thing that you say because that's what lawyers say. That Atticus Finch is like the archetypical prototype of the good lawyer, the honest lawyer, the ethical lawyer. It's who everybody wants to be. I do. I wonder if that was really ever sincere. Karina Cameron, killer/killers had to know they were going there. Who knew? Southern Gigi, this judge must answer to someone. We must get her off the bench. How? We vote her off. That's the only way to get her off, really, as a practical matter. She's got to be voted off. Judges getting removed is extremely rare and unheard of. It just is. In like really egregious situations, okay, maybe they'll be reprimanded, don't do this. Like the disciplinary body will tell them, don't do this. Situations where sometimes a judge is struggling with something like addiction or mental health, or, in an abusive situation or something like that. Maybe they'll get suspended, maybe they'll be like, you need to take some time away and sort out your stuff before you come back to the bench. But actually getting removed from the bench is extremely rare, extremely rare. So it's going to be up to the voters to vote her out. And she's going to be up in 2026. So it's going to be very important that this not be forgotten, which, might be one of the reasons why it didn't get televised. So that whatever happens at the end of the day, it will all just fade away into obscurity. And the modern day memory is very short term. Very short term. So we got to remember, we got to remind people, and we got to hold her accountable when it's her time to be reelected. Mudbug with a super sticker. Thank you for that. Donna Brack, Andrea, I just looked up where you went to school. Thomas Jefferson School of Law, top 1% entrance exam. Wow, Indiana is lucky to have you covering this case. This may not be what you're thinking of, because my law school is actually not. My law school doesn't even exist anymore. The reason I went to Thomas Jefferson School of Law is because at the time that I went there, their financial aid program was essentially just based on your LSAT score. I did very well on my LSAT. So I qualified for full tuition scholarship for Thomas Jefferson. That made it a very easy decision for me because, like I said earlier in the stream, coming out with debt is enormously limiting, and it's a real trap for potential lawyers. And it was important to me to have the freedom to be able to, explore options and not be kind of stuck on one particular path just because of the financial pressure. So Thomas Jefferson had all kinds of issues. It was one of the schools that got sued by students who had claimed that they had misrepresented like employment prospects after getting out of the school. I believe Thomas Jefferson was the first case that the case survived summary judgment, like it proceeded to go forward to trial. I don't think they actually did try it. Like, I think there was a settlement, but most of those cases got thrown out at the summary judgment stage. Thomas Jefferson was the first one that didn't. And then subsequently there were issues with its accreditation. And so it lost its accreditation status, and that was pretty much the end of the road. So the school is gone now. School wise, it is not prestigious at all, but it ultimately doesn't really matter. All that law school really does is teach you where to find what you need to be able to engage in your legal reasoning process. And so, I know how to research the law. I know how to analyze the law. I know how to apply it. I've had a long time in practice that I think speaks more for my qualifications and what I do than where I got my degree. And so if we were going to like look at resume items, I'd say forget my law school, put my name in Westlaw, and then see what you find there. Tell me what you think of that, because I'd put that record up against pretty much any other lawyer that's out there. Apple Gem PB, my nephew is in law school part-time while working to avoid the debt burden. I was concerned at first, but glad now he has the ability. Yeah, I think that's a really smart way to do it. There's been a whole issue too with like some places in the country, like in urban, it just tends to be in urban settings. There's way too many lawyers. And so lawyers are coming out of law school and they can't get jobs, and they end up getting like these low paying document review, things that won't pay their bills, certainly not their student loans, and potentially not even being able to really go into law at all. On the other hand, you have rural areas where they have a massive shortage of lawyers. It's the population of lawyers skews older, and not nearly as many young folks are coming into these areas. So as time passes and the older lawyers kind of age out, retire, move on, we don't have nearly as many people coming in to fill those gaps. So we're having a lot of issues with shortages of public defenders, just other kinds of areas where there's a lot of need. So that's another thing that I will often tell people that are considering law school is consider being in a rural environment. It's just there's kind of ironically a lot more opportunity there than there often is in a lot of the cities. Charlotte, don't know how you do it. I was an alternate on a jury where there was a guilty verdict based on what I considered to be a bogus confession. The defendant tried to keep out, still stays with me. I would imagine that would haunt you. Yeah. I think being an alternate is probably the hardest position, of anybody in that room. This alternate jury process that they have in Indiana. So the alternate jurors have to be there for the deliberations. They have to be present. They just have to sit in the room and keep their mouths shut. This was another, like, you got to be kidding me. Everywhere that I've been, that I've heard of, the way that the alternates are handled is they're just temporarily excused. They get to go home, go back about their business. They just remain subject to those orders that you not talk to anybody about it. You don't consume media information about it, all that type of thing. In a sequestration type of situation, they probably wouldn't get to go home. But they're just basically released from the process. They get to entertain themselves, within the limits of the sequestration, as they would see fit. But that's not how they do it in Indiana. They got to sit there in the room and listen to what's happening and keep their mouths shut and not being able to influence that at all. That would kill me. I don't think I could do that. So I do appreciate that it's a very, very difficult role to play. And you weren't responsible for that verdict, but I can understand a feeling of helplessness there. Lisa Stenson, could the state have extended the same courtesy to the girls' families by not showing their naked bodies to the public? I would be wondering why they didn't if I was on the jury. It was very much discordant. Now they did like censor, so to speak, the videos. So like you don't see the girls' private parts exposed. And even the eyes, the eyes are blacked out. You don't see that. So, I mean, it helps a little bit. It's still pretty bad. It's still really bad. But there is that little bit of dignity that they gave them. I think it's a fair question to ask. I do. Pantufel, my dog's names are Atticus and Scout. Great names. Favorite book, movie, play, sending pup love to you. Thank you for defending the Tom Robinsons of the world. It's been an honor and a privilege to stand next to the Tom Robinsons of the world. And that story is really a way to drive home the burden that you get from this job. Trying your best, knowing what the right outcome is, and it's out of your control. It's out of your control. It's hard to find peace with that sometimes. Jessica Pinky Mingo, don't forget daylight savings. You get an extra hour to sleep in, and I plan to use it to the fullest. Valencia, Ripple is my favorite Grateful Dead song. It's a wonderful song. I don't have a favorite Grateful Dead song because it's whichever one is playing. It really is. I mean, I know that that's like the joke. It's really whichever one is playing. I love Terrapin. There's like a depth to Terrapin that I really like. Terrapin Station. I love Ripple. Of course, I love Ripple. Love Broke Down Palace. Broke Down Palace is one of those songs that's like gotten me through so many hard times for decades. You know, a lot of wonderful, wonderful Grateful Dead songs. Genji Probs, I'm a skeptic and always aligned with the defense unless until the state proves charges. I'm also trying to take it in from various streamers, but it's like there are two different trials going on. Any insight? I mean, it is, you know, it is like two different trials are going on. I noticed that. I mentioned the other day when we watched that interrogation video and people heard all kinds of different things. Like it was like we were not watching the same video. Some of it, I think, is just it's because you're listening with an expectation. You know, I think that can happen. If you're listening with an expectation, then you know that's what's going to catch your attention. If you're not expecting something like okay, something that you can be surprised might catch your attention, but otherwise, you know, a lot of the kind of background, it just might not, if it's not confirming what you're expecting to hear and it isn't like otherwise surprising, a lot of those details can get lost in translation. So I think that's a big piece of it is people watching with an eye to what they expect to see. And by the way, you know, I'm not trying to exempt myself from that either. You know, I'm sure I have an expectation of seeing a weak case just because that was my impression coming in. You know, my impression coming in was I think this is probably weak. But I really do think I was very open to being persuaded to the contrary. But yeah, what I saw was the case getting weaker and weaker the longer the state went on. But it just depends on what you consider strong in the case. If those confessions landed, then the buildup, you know, if you believe, you know, that those confessions are legitimate, then yeah, when those landed, then that was going to strike you as a really strong moment for the state's case. And if you're not really receptive to the possibility that they were essentially coerced, they were under duress, they were the ravings of a psychotic man, a man who is past his limit, he's broken past his limit. Then the context, you know, all of the surrounding circumstances around those statements, you're going to see those differently. So really does. We just all come with different things to a case like this. Shy gal, you're brilliant, and thank you for being our eyes and ears. It means so much. I wish I could do more. Well, you guys are doing plenty. You're very, very supportive, and I'm very grateful for that. Mudbug has gifted a membership. Thank you for that. Kate E, infinite thanks. Why do you suppose neither side asked Doug Carter about why he asked the FBI to leave? Yeah, I answered that. I think it's a situation where there's not a good answer. Either the defense doesn't know what the answer is, and so they're not going to risk it. Or he already gave some answer in his deposition and it wasn't helpful. It was just some kind of, you know, kind of excuse, some kind of bureaucratic type of explanation. So S. Nair 499 super chat. Thank you so much. Peggy O, what a long, crazy trip it has been. A long, strange trip. Indeed. Looking forward to going home, baby, back where I belong, back home, sit down and patch my bones, but then get back trucking on. Love you and your content. Thank you so much. By the way, your name, yes, I recognize your name very well. Very well, sweet Peggy O. Thanks for being here with us and being such a familiar face on the channel. Jen X Gianna, Yana Strickland. If acquitted, his lawyers better have a plan on how to get him out of that town within the hour. That really worries me. Yeah, it does for me too. It does for me too. I'd be very concerned about him and his security really anywhere around here. And that troubles me so much because, both Rick and Kathy they're from this area. They're local to this area. This is their home. This is their country. And the reward for being innocent and being wrongly accused is potentially being exiled from your home. Just a whole different flavor of what justice really is, right? PDF photography. It's amazed to me that another judge wasn't assigned after Gull removed the defense team and had the writ issued against her, even if just to avoid the look of a conflict of interest. Their view is that, the way Indiana law is written and the way that they decided the writ, the request to disqualify her that was part of the writ was that you can't rely on her rulings to show bias. So in the absence of some kind of, personal interest, like a personal financial interest that's in conflict, or a personal relationship that's in conflict, or some kind of behavior that is not related to the ruling, but is, more related to like judicial demeanor and like, how you're treating the parties disparately or something like that. If it becomes to an extreme, that can give rise to the appearance of a conflict. But since Indiana says we don't go by the rulings that can establish, then she can sit up there and she can rule against the defense over and over and over again. She can make all the bad rulings she wants, and the remedy for him is to appeal. And that's Indiana law. And the only recourse to that, go to the legislature, have them change that. Have them set different qualifications for judges, grounds for removal, so forth. The legislature has some room to be involved in that. Dory, prayers for Richard Allen and Kathy. This trial is justice for Richard Allen. Sadly, no justice for Abby and Libby until a righteous investigation occurs. Yeah, justice is a long shot really for anyone in this, for all the reasons that we've talked about. And that's part of the real tragedy of this case. Karina Cameron, I'd find out what ATMs Brad works on or with Cameron. That's a great idea. I wonder if they were able to follow up on that. See, the fact that it only came out 2 months ago, it's the trial by ambush. You don't necessarily have time to go through all this. And video is often lost after all this time. That would be a thing that would potentially be worth eliciting from the defense. Had you followed up on this back in 2017 when he provided you with this information, when he was clearly under suspicion because they got his gun. They checked his gun to rule out his gun, which they weren't able to do. You might want to go verify his alibi, his timeline. Potentially just another thing that they never bothered to do. I think that's a really good point. Beer 30 Lacrosse, what was the highlight today? You're awesome. Testimony-wise, the highlight was clearly Indiana State Police kicked the FBI off and wanted the file back. Didn't want them to retain any of the information that they got from the investigation. I mean, to me, that's pretty significant. Spirit in the night. I just can't get over how the third party is just brushed under the carpet. Thanks for your hard work. It just seems so incredibly unfair. How are you supposed to defend yourself if you can't point out there's legitimate reasons to be concerned about other people? T Crow L, thank you for the honest coverage on this case. I'm in Monticello, the town north of Delphi. Let me know how to get a home cooked meal to you. Oh, you're very sweet. I appreciate that. I'm doing okay. Don't worry about it. I will survive. And I actually, I'm optimistic that since I don't have to be spending time on writ proceedings and stuff like that now, I will. I like to cook. I will have the ability to make some home cooked meals of my own. Hold on for a second. I got a cough here, so I'm going to mute my mic. Shiraz, grateful to Jeff, line sitters, mods, and everyone else supporting Andrea in this endeavor. Fantastic team here. It's been a wonderful team, and I include all of you in that too. All of you that are watching and supporting and making it clear that this matters. You know, it does matter. Thank you all for that. Mudbug is gifted a Burkhart membership. Thank you for that. Jenny Boo, I don't get excuse of third party. Explain, please. There's been a lot of litigation about the early stages of the investigation where there were other individuals that were under suspicion, and there is, from my perspective, some fairly compelling and intriguing evidence against these individuals that seems to be at least as strong as the case against Richard Allen, and potentially more strong because it has the potential to explain some of these strange characteristics of the crime scene. And so these individuals were cleared during the investigation for reasons that, to my eye, do not appear to be particularly unquestionable. Like they're a little bit sketch. They're a little bit sketch. Things like, one of them has an alibi because they went to a hospital in another town, and that was never apparently followed up on. We just took their word for it. Like we did not take Richard Allen's word for it that, he was there at 12 to 1:30, 12 to 1 or thereabouts. Wasn't there during the time of the abduction. Another individual, he's got an alibi because he was at work until like 4 o'clock. So it couldn't have been him. But we have medical testimony here. We can't pin down the time of death. And there's no objective evidence that says there has to only be one person involved. Logically, it seems to make some sense. Plausible, more than one person involved. So one of these other people that was under suspicion, clocked off at 4 o'clock, therefore cleared, but the medical evidence is that the time of death could have been any time between the point when the girls were abducted and the point when the girls were found the next day. So it is a partial alibi at best, but that was enough to just walk away. So very different decisions being made with respect to these early individuals than was shown when it came to investigating Richard Allen. And so none of that is being allowed to be shown to the jury. They don't get to point out that there's reason to believe, enough reason for the police to have investigated this pretty extensively before they just kind of dropped it for reasons that seem a little sus. He doesn't get to bring any of that out to the jury. So it really calls into question your ability to defend yourself if you can't point out those kinds of facts. Pamela Scott's a YouTube member now. Welcome, Pamela. Annie Clark is also a member. Welcome so much. Gustavo Vera, would you say this case is in some ways similar to the West Memphis 3 case? I presume you're familiar. Yeah, I am familiar with it. There's definitely similarities. The Reed technique is there. Now, the Reed technique didn't work on Richard Allen. We just kind of got to see it and how it works. But it did work on Jason Baldwin. Jason Baldwin was a vulnerable juvenile, had some cognitive deficits, and it did work on him. They basically promised him he'd be able to go home if he told them. And so he gave them information and they worked hard to make it fit. And it turns out, here all of these years later, it didn't. And now we got, DNA that exonerated them as far as I'm concerned. Of course, the DA took the position, no, it doesn't exonerate them. And so, yeah. I definitely see some commonalities, mostly just in how the tunnel vision can work in an investigation. Once somebody comes in on your radar and you focus in on them, then everything just becomes a process of trying to confirm that. It doesn't become an open investigation, a following the facts, following where the evidence leads. It becomes a trying to make the evidence fit the facts that you want to establish. Bobby Prince is a YouTube member now. Welcome, Bobby. Michelle C. for the Flower Fund. Thanks for everything you are doing to shine a light on this injustice. Yeah, I'll need to go find a place to get some flowers tomorrow. Hempland, Texas, thank you so much for your dedication. I truly appreciate your detailed notes and lives each day. This work is so important. I usually am replay crew, but I'm actually here for a live. Please rest well tonight and tomorrow. Well, welcome. I'm glad you were able to make it here for the live. Glad to have you. Appreciate your encouragement, and I will indeed rest very well tomorrow. Sabrina Cerna, Andrea, should the Carroll Comet reporter be reprimanded by Judge Gohl for looking at Brad Rosie's laptop and reporting on these camcorder videos? I saw that article, and I found it quite ironic that this particular reporter who is reporting these details that the judge has clearly indicated were for the jury's eyes only is the same reporter who was nearly got Ali Mata kicked out of the trial. Because she went to look at the exhibits, beyond the bar while not being a member of the media. And then was later, very self-congratulatory about how she would do anything to enforce the court's order. So more than a little bit of hypocrisy there. I don't think there's really a basis for the court reporter to be reprimanded because they have First Amendment protections and they basically can't be gagged. If they get the information, then they can report it. It's just a question of whether you should and whether that's really the appropriate and ethical thing to do. It would be like, for example, if you happen to discover the jurors' identities, should you report that? Of course not, and nobody would. So, similar line of reasoning to me. But you can look at that coverage from that particular reporter and see, you can see the bias in what's chosen to be presented and what's chosen not to be presented. So I think that really, that decision to violate the court order, to put that stuff, not the court order, but to clearly violate the restrictions that the court had intended to put on the public, the availability of this information to the public. That speaks very much to that reporter's motivations and intentions. Maureen Gunn, thank you for your keen legal and humanitarian point of view. You have been so helpful to so many. God bless you. Thank you so much for that. You guys have so many kind things to say. Ms. Jake, enjoy your sleepy Sunday. Thanks for all you're doing. I will enjoy it so much, and I appreciate your support. A numbers girl, retired LEO, now a forensic accountant. I am not sure what format they produced the report about lost evidence, but perhaps a forensic expert tell them when it was created, or perhaps they have proven their point. Thanks for all that you do. Yeah, the lost interviews that supposedly had a list. That's, you could just see from Andy Baldwin's reaction. There's no list. They've never been given a list. This is just something that he made up. But same thing with that report, these reports that he made that were undated. I think that's potentially a good idea. If they have that and they can subject that to forensic analysis. I doubt that they've done that because we would have confronted him about that. But yeah, interesting possibility. Rebecca, thank you, Andrea. What about Down the Hill? That didn't sound aggressive or stern. Does that make you think the girls knew who the voice was? No, not particularly. Not particularly. I mean, it wasn't like it wasn't aggressive or stern, but I think it was firm. It was firm. It was it wasn't like, please, maybe you should go down that way. It was a direction. I think that came through crystal clear. So I don't take a lot of issue with the down the hill voice being, related to the abduction. I understand it's limited context, and yeah, it can be other things. But I don't think that's, I think it's pretty reasonable to see that, especially just under all the circumstances of the case. That was a direction, and that was somebody who was involved in it. Now, again, having seen kind of the video and how it evolved and the sort of timing of things, I do have some question about whether the guys down the hill voice is the same voice as the person who's seen on the bridge. because I'm just not really super convinced that the timing works for that. There's just enough of a gray area there for me that you would expect he would have had to have run, because we see Abby running, and we see Abby is, is breathing. And if she's scared, I mean, that's going to contribute to that too. But she's running across the frame, and the man is considerably behind her. And so for him to catch up and be saying that moments later, seems like he would need to be running too. Doesn't sound like the voice of a person who's been running. And just given the distance he was from the end of the bridge, I don't see him covering that distance in enough time to be the voice of saying, guys down the hill. I could be wrong. That's just my impression from what I remember from that video. Ashley Nudo, it appeared Abby had rigor, but not Libby. Strange. I don't believe that was, I don't believe that has come out in evidence. The testimony was that both of the girls, I believe, rigor mortis had set in. But again, we're talking about the time frame of like when they're being collected is when they're being handled. And so it's after they've been discovered, after the crime scene investigators have gotten there, after they've gone through and done their documentation and swabbing and all of that type of thing. We didn't really get a time frame about how long that would have taken before they then proceeded to collect the bodies. So it's just possible that this was an ongoing process. Vivian James, was it a green handkerchief or scarf? Was it something that looked like it could have been used as a blindfold? We didn't get a very good picture of it. They've described it as a handkerchief, as a headscarf. To us, it's just sort of like a wet looking, lump of green material. Possible it could be a blindfold. Possible it could be a gag, something like that. Claude Simeon, you are better than the rain that enables wine, a constant proof that God loves us and loves to see us happy. Ben Franklin, wine, not beer. Well, that's a very nice thing to say. Appreciate that. Iriska Feloni, 56. Sock account, sorry. Has anyone seen the pics of Goal at Abby and Libby Memorial softball games? Goal's daughter and her team won some, given prizes by Abby and Libby's family. Not saying this is wrong, just a bit. It's a good point. It's probably not enough to get to, an actual conflict, but it's not a great look. But it is a small community, and it, the reality is things are a little bit different sometimes in a small community, because you can't avoid, the judge isn't required. The judge isn't required to be an island, but the fact is, I guess I backpedal on this a little bit because, Judge Goal isn't a resident here. This isn't her county. She's up in Allen County in Fort Wayne. So yeah. That does kind of make it a little bit worse. She would have had to go out of her way, to be down here for it. Oh, I don't know the softball. I don't know the softball situation. I guess now that I think about that, when I played sports when I was a kid, we travel all over and stuff. So it does happen. But yeah, I agree. It's not really the best look. Paula Semek, did they ever ask if they considered if the scarf could have been the killers? Also, listening to you talk about being better than the monsters, are you against the death penalty? Appreciate you so much. 100% against the death penalty. Absolutely. I think that makes us no better than a murderer, because you're putting yourself on their level. Nobody asked if the scarf could have been the killers. It's just something that I think is going to be an inference that's possible, from this evidence. It's something that they could argue. They may or may not choose to focus on that. There's going to be so much to talk about, and they're going to have to. You have to target your closing. You always have to edit. You can't say everything, or you're just going to lose them. Christina B. Thanks, Andrea. When this is over, don't forget to check Ian Runkle of the Bailey 24-hour live stream raising money for Stollery Children's Hospital. Yeah, I love Ian's live streams. If I'm not literally falling asleep when we get off, I will definitely go over and check that out and see how things are going. Sarita Banana, shrimp ceviche. Sorry, I'm like an hour behind. Congrats on the good food. It was pretty good food. And just kind of Nice to have someone else make it for me for a break. Not that I mind making my own food. C straight. Has there been a discussion regarding RA's physical ability to move a 200-pound body? He was pushing 50 years old, 5'4" tall, 180 pounds with heart problems. That seems like a stretch. Yeah, it hasn't. This is the type of thing that's argument. This will come out in closing if they want to emphasize this. They have, reminded the jury in this context of like Libby being potentially dragged, Libby being moved, not having drag marks. Yeah, she's 200 pounds. Like that's a lot to lift all the way off of the ground and then move and then place somebody else, somewhere else. And so what at the time, the way that they addressed that was by suggesting, well, and so one potential explanation of this event is that it would be two people that carried her. And that has the also convenient explanation for me of how, her head potentially would have fallen back and then created those blood flow marks that were seen on her face. But these are very good points. I think the heart problem, is an especially good one. Libby was quite a bit bigger than Richard Allen. Doesn't mean it's impossible that, he could do it, but it does, you do question the plausibility of that explanation that the state is giving us. RJP became a YouTube member. Welcome to the channel. Dory, all RA was doing, if you see something, say something. Yeah, literally the day that they ask for information and he contacts them, and he agrees to meet them right away, like at their convenience. I'm out doing stuff, but go ahead and meet me at the grocery store. And then they turn around and make that look like he's trying to avoid them coming to his home. Yeah, see something, say something. He's there to do the best he can to try to tell them. And he seems to be pretty imprecise in his speaking when he's giving them the information because he wants to be inclusive. He wants to tell them every possibility it could be. If he doesn't remember clearly, well, he could have parked here. He could have parked there. He could have, driven that way. He probably didn't drive this other way because he only even knew that there was this way to drive because he stumbled upon it accidentally. So he would have gone the other way, but it could have been in this time frame. Yeah, he seemed like he was being very open about what he did and what he saw. And it clearly caught absolutely nobody's suspicion right at the outset. Jeep Girl, not new to YouTube, but new to your channel. I absolutely love your show and your coverage of this trial. You are truly doing an amazing job. Keep being you. You lead from the heart. Thank you so much for that. Always appreciate new folks coming along and enjoying what we're doing. So I hope you stick around for a little bit. There's plenty of trials to talk about. Shauna King, the white van has been known and reported on from our local media for years. I hope you write a book. The elders of these unions who hold high-ranking positions need exposed. It's very real here. Thank you, Andrea. The more I've heard from folks who are local to this area, the more I have heard so much of these concerns about just how deep some of this stuff goes. The culture, the old boys club, all that stuff. And it is. I mean, I understand how those systems can be very entrenched. And then when you're in an area where there's not a lot of population turnover, cities, people come and go constantly. But in a lot of these rural areas, people have been here for generations. And so those patterns can be entrenched, and that can be part of how, power gets consolidated and it gets concentrated, and it becomes very, very difficult, to shift that. Jody J, at the conclusion of this trial, regardless of the verdict, praying not guilty, you need a few days off the grid and soak up some Zen. Oh yeah, maybe McClelland is on the same track as Casey Jones. Better watch his speed. Trouble ahead, trouble behind. Lisa Shelton, I'm sorry that question confused me so much. Am I understanding there was seminal fluid present without sperm found in the girls? Has Richard Allen had a vasectomy? So the evidence was She used a preliminary test for the presence of seminal fluid. What this does is it detects certain proteins that are present in seminal fluid that are typically not present in females biologically, but they can be under certain conditions. So this is a presumptive test because the fact that these proteins can be present in women means that it can't be conclusive. Like, you can't definitively rely on it. It's just a piece of information that then needs to be followed up on. Her testimony was that you can't both do a confirmatory test to verify, yes, this is in fact sperm, seminal fluid, that this is causing this protein reaction, without preventing you from being able to test it for DNA. So their priority was to try to find DNA. And so they did that test and they found no male DNA was present. And so that really means that there are two possible ways to interpret these results. One, the seminal fluid test was a false positive. There's no seminal fluid there. There's just a reaction from the test that it's not a 100% confidence test at all. It's, known to be wrong a significant amount of the time. Or there is seminal fluid in there. It just lacks the presence of male DNA, and that's consistent with vasectomy. So, or, some other type of sterility that means that sperm is not it's not in the seminal fluid. So those are really the two possible interpretations, and we don't know which one of them they are. We really can't know. Elizabeth Stark, it can't be said that a van being in the trail at the time is something only the killer would know. Only after RA made a statement during a mentally healthy crisis, law enforcement talked to Brad Weber. Brad Weber changed stories. Yeah, the white van in the area. I don't know if they knew anything about what Brad Weber was driving. What Brad Weber had a white van. I don't know. But that is a question. If there is anything about this in the discovery, that could have been something that seized on. And I think, like other folks have pointed out, it seems that something about white vans or white trucks was a part of a lot of the internet discussion conversations that Dr. Walla seems to have been, exposed to. So a lot of possible issues with that. But yeah, the changing story is a big problem. Starchasm FF, New York State doesn't allow televised cases, and we have Rex Heuermann as the Gilgo Island serial unalived. Also, Diddy trial, we will not get to see. Diddy trial is definitely on my radar. I didn't know that about New York, so that one is potentially on my radar. That's one where I tend to like cases the most where I'm not sure, and I mean, you're never sure until you go through trial. But Rex Heuermann is one, like, from my review of the probable cause affidavit, it's really strong. So I don't have a lot of doubt about the state's ability to meet its burden of proof in the trial in that case. It doesn't mean that it isn't going to be very interesting and that there won't be a need to cover it. So it'll definitely be on my radar. But like, if it comes into conflict with something that is possibly a little bit more in question about what the right answer is, then I might defer to the other one. But we'll just see. That's a great suggestion, and I appreciate it. Southern Gigi, can you file a motion for judge to recuse herself for judicial bias? I can't do that because I don't have standing for that. Only the parties to the case have standing to take actions about the case. I don't have standing in the criminal case. I have standing as a member of the public to ask for access that the public is entitled to this criminal case, and that's pretty much the scope of my ability to do things in the case. Auto Doctor 911, since RA is competent for trial, does this mean they can't lock him up after not guilty verdict for mental health reasons? This is a good question. And the answer is not necessarily, because the standards are not the same. Competency goes to your ability to assist your defense. Locking you up for your mental health is a question of whether you are a danger to yourself, a danger to others, or gravely disabled, meaning that you are unable to take care of your activities of daily living. He's not manifesting any of those signs. He's clearly dressed and appearing at trial and functioning, and he is eating again. He's got weight on him. So it's very unlikely that standard would be met. But I like how you're thinking, because that it is legally possible. There's nothing that precludes a person from being found not guilty and then instantly, being detained for evaluation for a mental health commitment. That would, that would give away the game if that happened. T down 43. Doug Carter sent the FBI home. That's what he said. What does he have to hide? We'd all love to know. With all these mistakes, it's obvious the fix is in. Yeah. Way too many problems with the video recording system, the technology that you just somehow managed not to be able to explain. They continue to recur for strange reasons. Like, you'd think normally if you're having problems video recording things, you would fix that. No, they just keep happening. But then they also only happen selectively. It's only during Jerry Holman's interview. Doesn't seem to happen during the other interviews. And it seems to be, if that was a consistent thing that you knew about, that there's a lag about the video getting started, then everybody in that police department would be aware of it. And you would wait until the lag is passed when you do the things that are of critical importance to a case, like documenting, Mirandizing the person that you're interrogating. So it's all sus as hell. And it's just it's very obvious. Beer 30 lacrosse. Andrea, can you explain what would be the jury verdict detail? Typically, the jury verdict is literally just guilty or not guilty, and that's it. That's it. They don't give us any sort of detail about what specific facts they think are true, what their reasoning is. They are allowed to discuss that after the fact if they want to, once they're released, from further service, but they are under no obligation to do that. And they typically, you can't typically force them to talk about it at all. So it'll be up to them if they want to share anything about their experience. Lisa Shelton, case is a nightmare. Would it be better for him to be found guilty so that it could go to the Supreme Court to be overturned? No, absolutely not. Just because of the time involved, and he's continuing to be held during that process. He's continuing, it's just no. Absolutely, the best outcome for him is a not guilty verdict, and then it's over. He gets to go home. Not guilty verdict. He's walking out. He's walking out. He'll be walking out of the jail that day. So that's the best possible outcome for him. Gingy Probs, for what it's worth, I think the movie he Googled was Hard Candy. Okay, yeah, I don't know. I didn't recognize the movie, but I got to admit I'm not a connoisseur of hijacking movies, so I didn't know. But that's interesting. Good insight. Christina Jarvis, I hold you, Bob, and Allie in high regard. When you see something that is not right, not fair, not just, you have to speak up. You have to say something. You have to do something. John Lewis. Well, thank you for that. I'm very proud to be associated with Bob and Allie. They have been obviously a big part of bringing attention to this case and keeping it in the public eye. I respect them as attorneys and their views on it. So that is high praise to me. Carrie Mache, is there a term for incarcerating someone in order to make them so crazy so that they confess? I don't know that there's a specific term for it, but we'll probably be calling it Richard Allening somebody in the future. If there's not already a better word out there that I just I'm not thinking of, because I'm still not caught up on my sleep. I mean, it's railroading, it's framing, it's a frame job. Kelly Jane, PD said in 2019, the first bridge guy was no longer who they were after. Then RA gets arrested and bridge guy 1 is back in the picture while bridge guy 2 is forgotten. The whole process of which bridge guy and the bridge guys are the same and all that. It's just, I mean, that's part of the background that we know from following the case, but it hasn't come out at trial because we didn't get to use those sketches and that part of the context and everything. So the jury doesn't know any of that unless they came in with that information already. Yeah, it just shows how flexible law enforcement is right up until they have somebody in their sights. And then suddenly nothing else is possible except that this guy is guilty. Doxy mom, Carrie, do you think he was forced to confess? I do. I don't know that I think like in the sense of people, I wouldn't rule it out, just given the threats and so forth. I wouldn't rule it out. I do have some concerns about this, the detailed one from Dr. Walla, it's not recorded, and Dr. Walla lacks a lot of credibility with me. So we're dependent on her notes and the veracity of her notes and her reporting about that. It just does seem potentially a little convenient. Suddenly he's producing all of this detail that's never come up in any other context. Got to be a little bit concerned about that. Rachel, was Richard Allen's blue jacket entered into evidence and shown? Bridge Guy's jacket does not look like a Carhartt jacket to me, more like a windbreaker. His does look like a windbreaker. I thought the same thing. Richard Allen's blue jacket, I don't believe the jacket itself is in evidence. I think that there's a photograph of it that's in evidence, and so it's kind of hard to say. I mean, I'm sure if we sat down with the photograph of Richard Allen's coat and the still photo of Bridge Guy, we could sit there and do comparisons. Look at like how wide is the waistband? Is it a cinched waistband versus a straight, a loose fitting waistband? The collar, shape of the collar, shape of the cuffs, all that type of thing. We'd be able to make those types of comparisons. But we're not really allowed to have those copies of the exhibits. So we'll have to wait until after trial to take a look at that. Jenny, I heard the guard with the Odin face tattoo testified and wore makeup and glasses to cover the tattoo. Is this true? I don't know if it's the face tattoo guy. The guy that testified was simply one that I was pretty sure by his name had been identified in the Frank's motions as one of the Odin guys. It just rang a bell, and I was pretty sure that that's what it was, but I haven't had a chance to be able to go back and look at that. I'm not sure that I know who has the face tattoo. Like I don't remember that person was named. So yeah, I don't know that this is necessarily the case. I thought it was one of the patch guys. So I'll see if I can look into that over the free time the next day. And in the days coming up, and see if I can verify that. Auto Doctor 911. Oh, this is the same question. Yeah, they could theoretically, but it doesn't look like he'd meet the criteria right now. Vivian James, did they interview RA's CVS coworkers? I'd think that he would have acted really strange at work after brutally killing 2 young girls. Yeah, you would think. You would think that they went and did some of that, but if they did, do I trust them to have kept it if it didn't produce them the answers that they were looking for? No, I would not. No, I would not. Auto Doctor 911, hung jury is worse than conviction, goal part 2. In many ways it is. In many ways it is, having to do this all over and no immediate recourse. The conviction, the problem, of course, is that now you're stuck. Now you are for sure going to Department of Corrections. You're not, having the safekeeping possibility of staying in Cass County, where it appears he is doing better. So that's certainly a downside. The time involved is certainly a downside, but you have the option that there's going to be review, and that certain things that weren't allowed in this trial that would be reversible. And that he would get the opportunity to have round 2, but under different circumstances as far as his ability to present his defense. It's likely that retrial would also be under Judge Gold. It's likely it would be. There's still nothing to disqualify her besides her obvious rulings being one-sided. But under Indiana law, they're not gonna they don't consider that. So. They're both probably going to be goal part 2. So it's just a question of now or later DOC review. There's upsides and downsides to both. Jane Doe, have they mentioned if RA had a cell phone with him on the trail? Seems like that would nail down his timeline. He, in his original statement, had talked about checking the stock, watching the stock ticker, and he talked about this in his interrogation in the video that we saw. And he testified that there was an app that he had on his phone that would allow him to watch the stock prices, and that this was basically his hobby. Then he was trading spots and trying to get rich quick, but realized there's a lot of risk in that, and so he doesn't do it anymore. And he also said that was one of the reasons he thought maybe he left the trail when he did, even though it was such a nice day, because he wanted to go home and watch the stocks on his computer, like on his laptop or desktop or whatever instead. So it does imply he had a phone. This is one of the pieces of information that's kind of been out there, suggestive, but it's not really clear exactly what the status is, because when they went to Richard Allen's phone, they seized a lot of devices. Like, there's no question they seized a lot of devices. I counted like 16 or 17, a lot. And according to the testimony that we've heard, the phone that he had in 2017 that he showed to the DNR officer Doolin, when he took his original statement, they got the identifying number from it, checked it against what they seized, and they didn't recover that phone. So it's not clear if that's like, if he's got every other phone he's ever had except for that phone, which would potentially be suspicious. That's potentially a problem. Or if it's just a situation where, like, he had old previous practices with how he handled his phone that, in the subsequent years he changed, or like some of his phones he keeps and some of them he doesn't for various reasons. Maybe some he's traded in, some he wasn't able to. We don't know. We don't have explanations for that. But we do know that, yes, he had a cell phone in 2017. He seems to indicate he had it out on the trail. Despite that, there doesn't seem to be tower data that identified the phone on the trail. So these are questions. These are questions. It's one of the reasons why I think one of the jury questions had been, is it possible that just the towers were malfunctioning that day? Because that could potentially explain, if Richard Allen's out there on the trail using his phone, but the cell tower isn't recording him, that could also maybe have something to do with why Abby and Libby's phones, or Libby's phone went silent for as long as it did. So the jury asked, did you ever check for any tower issues, any issues with the tower? And they said no. They said no. So we don't know. Beer 30 Lacrosse, your petition writ is badass. Thank you for that. I was pretty proud of it. I thought I did a pretty good job with it, especially considering the circumstances. Dr. Tiny Toff, if jury hangs and state opts to retry, can defense petition higher court for goal to be removed? Can they showcase this trial as evidence of state bias? Nope, they can't, because they can't rely on her rulings to show that she's biased. Nope. Truth Seeker, do the alternate get to give their opinion to the jury? No, they do not. They have to sit there in the room and keep their mouths shut. They don't get to say anything. That would kill me. I don't think I could do that. I don't think I could do that job. Very, very frustrating. Shauna King, like a John Grisham novel, however stranger than fiction, Andy is sharing the truth, and the elders cover up for these radicals is what is happening. It's so heavy here, especially northern Indiana. I mean, I'm not local, so I don't have insight into the culture here, but the number of local people telling me stuff like this and just how deep the culture goes, it's compelling to me. It's very compelling to me. I hear this from a lot of different people. Gen X Girl Lawyer, great work, Andrea. Thank you so much for that. Invader Brand, can't stop thinking of Khalif Browder. I'm not familiar with that one. I'll have to look that case up. RL, thanks, Andrea, for all your hard work bringing the truth to the public regarding this trial. You're very welcome. Happy to do it. Cat's Out of the Bag is a YouTube member now. Welcome to the channel. Dr. Vonda K, as a PhD and Ed D, I can attest to your Ed statement. Every school should strive to teach students where to find what they need to engage in reasoning processes. I know where to research, analyze, apply, practice. Thank you. That's the goal. We're not trying to run indoctrination centers here. We're not doing anybody any service if we're not teaching them how to think. If we're just teaching them what to think and not using all of that capacity that our brains have to process information and and be able to build our entire civilization from it. I mean, it's really amazing, the human brain. So very much a process that we should be focusing on in the education system. So thank you for that comment. For six kids UK, the ATMs put on a journal when they are serviced and who did it. I know because I prosecuted a case in the UK. I'm sure that there are records of this. I mean, yeah, I'm sure that there are records of this. I think the question is, did they hold on to this for so long? You know, the ambush method, that there wasn't going to be viable ways for the defense just because of the time that's involved. You got to get a subpoena. You got to serve the subpoena. The subpoena's got to give a reasonable time for compliance. If the party is going to object to the subpoena, they can move to quash the subpoena. Then you have to deal with that whole process before there's any obligation to turn it over. 2 months is a really short time in court time. Really short time. And so I would love to think that they would be able to get something like that. I think that would be exceptionally helpful. I really do. I really do. It doesn't seem like the only way that they can get there is just proving, that Brad Weber contradicted himself. If they can disprove it, that would be fantastic. JD, Judge Gold was a leading enthusiastic proponent of Indiana's pilot program for cameras in the courtroom, yet refusing them in this case is darkly sus. Fight on, Andrea. We're with you. It is sus. And it's just one of those, again, I just got to wonder, did she just never think it would be her courtroom? These other people, maybe, yeah, we should shine the light on them, but it'll never happen to me. I don't know. Stephanie B, cheers to messing up plans of hiding public info. I am behind on the stream. Thank you. Thanks for your reporting and lawyering, Andrea. Well, you're welcome. And it's been my pleasure to be a bit of a gadfly on the issue of public access. Summertime, someone in the chat asked, without the bridge guy video, where do we think this case would be? Cold. Thanks. Yeah. I mean, without bridge guy video, we don't know when. We don't know when they went missing. We don't know where they went missing. We wouldn't have the ability to really establish a time frame to be, trying to get descriptions of people saying they saw somebody on a trail, even though, of course, those descriptions sound nothing like Richard Allen. Yeah. I mean, I think if the case is this week, they have this little information after all of these years, even with that video, without that video. Oh yeah. I think this case is long gone cold. I risk a felony. It's finally come together for me, being able to read the name. Some of these are a little too clever for me in my sleep deprived state. I risk a felony 56. Sorry, this is my sock account. Have you seen any of the Facebook screenshots of Gold being friends with some of Abby and Libby's family? Not saying it's wrong, but no, I haven't seen it, but I did comment earlier, mention that something about the softball game and being very, very friendly with the family. Karina Cameron, is it possible that RA is bridge guy, but someone else did it? I mean, sure, I guess it's possible. It's not consistent with Richard Allen's account, right? Richard Allen's account is he went out to that first platform and never went that far across the bridge. Very insistent. He never saw the girls. And it would be difficult for me to imagine a scenario where, they're choosing to film him coming across the bridge. Something sus is going on. If the, guy is down the hill, guy is somebody else, then Richard Allen is there and like a witness if he's bridge guy. It's just, we need some kind of explanation for that. And there's nothing like that. So it's just, I don't really see that as being a feasible explanation. I think he has to not be bridge guy, for it to work. But I'm not convinced he's bridge guy. I don't think bridge guy is distinctive at all. He doesn't really look that short. Particularly compared to Abby and Libby being approximately the same height And just it's difficult with the perspective that you get on the camera. But yeah, not convinced that Richard Allen is Bridge Guy. MCM 11, because of all the law enforcement mistakes, I have a bad feeling that there will be a miscarriage of justice no matter the final verdict. Well, yeah, I mean, that's the bottom line. We trust the police. We rely on law enforcement to do things thoroughly and correctly and responsibly and professionally. And they absolutely fell short on that in this case. There's really no question about it. And then to see Steve Mullen up there on the stand chuckling about it, about how clever he is. Oh, you do it differently. I can't imagine if I was the families and you're up there laughing about losing critical investigative material. Bell Mayhem, can't thank you enough. If it's a hung jury, does he go back to the hole? Do you think after the videos, this influences the jury decision? I can't, just seeing the reactions that they had to it, the fact that it did appear to move them quite a bit. They had strong reactions to it. And so, yeah, I think it tends to influence their decision in that it goes directly to the circumstances that were surrounding him making these confessions and what he was enduring, and just being able to kind of, try to imagine that mind state. They have so much information about, the things that he was saying, not just the phone calls, right? They have the phone calls, they have the observation notes, the logs, the suicide companion logs. And now they have these videos. It's all things that they can put together to give them a very full picture of Richard Allen's life at the time that he was making these statements. And there's a reason why the defense is going to show the incel video too. It's just going to be a whole other part of the picture. So, yeah, I think that has the potential to influence their verdict, because if it undermines the confessions for them, then there's just really not anything to go on. If it's a hung jury, does he go back to the hole? At this point, no, because the safekeeping order was reconsidered shortly before trial. And so Cass County agreed that they could keep him. So at this point, it would seem that he would stay in Cass County. Suyan, Central Park 5 was a case where innocent people confessed a crime they didn't commit. There's a Netflix series about it called When They See Us. Yeah, there's been several. I mean, lots of high profile cases. Maybe not high profile. I shouldn't say that. It's relative, right? Like Innocence Project cases are probably pretty high profile to me, not necessarily to anybody else. But I pointed out not that long ago, there was a whole news story. It took over the algorithm for a while, because I think what happened is the guy won a lawsuit. It was a kid, like a 16 or 17-year-old kid, something like that, teenager that's interrogated, like brutally interrogated into confessing that he killed his father. And his father's alive. None of it happened. And they firmly convinced him that he had done it, and, broke him down and, gave him severe psychological problems. So yeah, it definitely happens. Carazola X, it feels like they'd have had an easier time getting someone to run for governor so they could pardon Richard Allen than put on the case with these handicaps. Amen. I mean, fair trial is an absolute uphill battle, and I'm just, if he gets an acquittal in this case that I feel that he's entitled to at this point, it's going to really be against all the odds, against all the best efforts to keep that from happening. Jadzia, 1969, no cameras in court here in the UK. Cases like this make me wonder what miscarriages of justice we miss. Thanks for sharing your insight with us. Does very much help to be able to see it with our own eyes. You just never know. The UK system is definitely very different with transparency is not a given. I was actually looking at one point, I was trying to hunt down a transcript of the sentencing hearing that was in I think the Manchester Magistrate Court. And the reason why I was hunting it down, it was Tank Davis, who's, boxer. He's a boxer from Maryland, if you're into boxing. His coach had gotten arrested flying into the UK. It was actually coming out of the UK. There was a firearm discovered in his baggage. I think it might have been a loaded firearm. So really bad stuff. He gets arrested. The UK is, I understand, not tolerant of things like that. So he was arrested. He was held for something in the ballpark of like 30, 40 days or whatever. He pleaded guilty, said it was just a situation where he forgot that he had it, didn't realize it was in his bag, never intended to bring it in, and ultimately got some type of disposition where he was able to be released and leave the country. He wasn't subject to what sounds like normally fairly severe sentencing for that type of crime in the UK. So anyway, I wanted to hunt down that sentencing hearing because I was just kind of interested in what was said and how the sentencing process works, what the justification was, the explanation for kind of departing from that presumption of a strict sentence. But I could never find a way to get access to it. Tried contacting the courts, never got anything back. So it's a very different culture of transparency in the UK legal system. Akira, Bridge Guy's hat. Has law enforcement checked old photos of Richard Allen or Ron Logan or Brad Weber to see if they ever wore the same type of hat? The hat type stands out to me. Heard nothing about the hat. Thoughts? We didn't hear anything about the hat. We know that Richard Allen said that he would have had a skull cap in his pocket. The picture of Bridge Guy looks like a cap. It looks like the taxi driver cap, like an old chauffeur's cap. Or like a golfer's cap, I think of sometimes. It's got like a Scottish kind of look to it. There is a video that Brad Holder posted of himself on one of his social media where he's wearing a hat like that. I think it was intentional. This is very clearly a taunting type of video for people who thought there might be reason to suspect him of being involved. But there's no indication of any hat like that being recovered from Richard Allen. And you would think if they had found a photo of Richard Allen in a hat like that, it would have come into evidence. So does not seem to be a connection with the hat. Kevin Dockery, could you tell where white van was supposedly driving, like down the hillside or body found side? Wouldn't the act of ending be more difficult than R? I'm not sure about the last part. As far as where the van was supposed to be driving, it was supposed to be driving on the driveway that goes underneath the high bridge on the far side. So where the girls would have been abducted. And so that's why they're trying to put these pieces together, because the idea would be, okay, the girls were ordered down the hill from this bridge. That would have initially put them on the road. They would then have to, if they're on that side, which seems to be the state's theory, he was going to rape them over there. They would have probably had to go down the embankment to not be seen from the road, because of course Brad Weber never reports seeing anything. So they would have had to be down the embankment near the river, where this has been described as a very steep drop off. So that's the story. No explanation for how they got there, why they were there, why it would have scared them to hear a car going by when they're in a place that would kind of necessarily have them be concealed from view, as opposed to if you go out across the creek, you're now in plain vision from where you can see, not just from, you can see from the bridge, you can see from the road, you can see from the other side. Seems like you would hunker down in your little safe spot if you had one. That's just my thought about it. Auto Doctor 911, no alibi after 1-3 home alone computer record. Not that we know of. I mean, possibly there's a lot of defense case to go still, so no idea. 6 Kids UK, I got ATM records nearly 5 years old. That's good to know. Yeah, I don't know that with records like that, I can definitely see them being maintained for a long period of time. I think the question is really just the ability of the defense to use the process to access them in the limited time that they had between when it was disclosed to them and then when they were, when we're set going to trial. I don't know if they even know like what ATM company I don't know if they'd even know where to look. You'd have to, depose Brad Weber, and there probably hasn't been time to do that. So that's just part of the sketchy part of this ambush tactic that they've been using. Carazola X, seeing all the people cheering on the prosecution, invoking the name of those two poor girls in this injustice. It's too much. Well, that's always going to be out there. There's always going to be people that have very strong opinions based on very limited information. Kate E., would you consider doing a mentoring stream with advice for non-practicing new and retired lawyers who are inspired to try rural independent practice or public defense but fear doing so? Yeah, I'd consider that. It sounds like a potentially fun thing to do. If you think that's something people would be interested in, happy to talk about it. Equestrian 100 makes me think twice about ever coming forward to give a tip. That's the very unfortunate takeaway from this. Had he never come forward, we wouldn't be here. Absolutely. Thank you, Andrea, and all mods appreciate you. We appreciate you too, and thanks for being here. Charlie T, don't forget Runkle of the Baileys. That's right, everybody. We're just about to wrap up here. So everybody head on over to Runkle of the Baileys. Go check out how Ian is doing with his 24-hour live stream for charity. It's a great thing that he does every year. Well worth supporting. Big J Dick. Great name. You should be nominated for a Pulitzer Prize for investigative reporting and win. Thank you for everything you're doing. You're the best. Well, thank you for that. I, of course, will never be even nominated or considered for anything like a Pulitzer because, I'm not in the club. I don't have that credential. And besides that, what I'm doing, I don't know that conventional journalists would really consider what I'm doing journalism because so much of what I do is talking about my own processing. I'm talking about what I think about what I'm seeing as much as I'm talking about what I'm seeing. And so that's, something that conventional media seems to think is something that they're like above or like don't do or whatever, even though it's very clear that they have viewpoints that get reflected in what they publish. But it's a very kind thing to say, and thank you so much. Celeste Moya with a super sticker. Thank you. Jeremy Morton is gifted 10 memberships. Thank you for everybody who got one of those. Sarita Banana. Brag, my man graduated from law school at 50 years old after being a union steward for 30 years. That is very impressive. Now an attorney for the Children and Family Law Division in Nashville. Good for him. His colleagues give him hell because he doesn't give up so easily on his clients. Well, yeah. It's important, the lawyer has so much potential influence over their client and just whether they have hope of things being better, hope of getting through this process that they're in, hope that there is avenues for change. I mean, all of that, hope that they can come back if they've made a bad mistake and they're going to pay consequences, hope that there is life after the end of that. So it's a very important role that the lawyers play, and that's why it's so important to keep that alive, to keep motivating each other, to do our best, to not let the hard parts of the job get us down and get us too jaded to where, we lose sight of that. The Squid, going to have to catch the replay. Thanks for this coverage. It's so important for everyone to know what their own elected officials are doing. Absolutely. We vote for these people. We should be allowed to watch what they're doing. 100%. Tim Downing, want a sense of what RA went through for 13 months. Watch Castaway. Castaway, he got sunshine and he got a volleyball, that he was able to make his friend. Richard Allen didn't even get a volleyball to be his friend. He's on suicide watch and they take away everything and he's got nothing at all. I mean, it's a good, but he had way more stimulation on that island than Richard Allen had in this tiny little cell. So yeah, take Castaway and turn it up to 11. I would say if you want a sense of what Richard Allen went through for 13 months, watch, I'm pretty sure it's Midnight Express. I've been trying to remember this movie for a couple days. It's the one about the guy, the American that gets stuck in the Turkish prison. Watch Midnight Express. I think that's That's maybe a little bit environmentally more similar. Although even in Midnight Express, he had social contact. He wasn't completely isolated. Karina Cameron, I truly believe that Kathy would know if Bridge Guy is Richard Allen. Yeah, I don't know. It's just one of those things that you would suspect that somebody who has done something like this murders, you don't just do this out of the blue. You've got something in your background that's going to be a giveaway that you are, prone to this type of behavior. This is like severe psychopathy. It doesn't just show up, in your late middle age. It starts showing up when you're young. You have behavioral issues. You have, conduct problems, often like early issues with law enforcement. It's something that people know. It's something that people know. So I would think if Richard Allen had that type of history, we would know about it, and we probably would have heard about it. But I don't think we have. Don't think we've heard anything like that. Okay, guys, that's it. That's all the comments. Don't send me any more. I'm ready to go to sleep, and I will feel obligated to read them. I'm talking to you too, Tim Downing. Can't misery. Yeah, misery. Another good one. Continue misery. Thank you, guys. I do. I appreciate your support, and I really enjoy the interactions that we get to have through these super chats. With the questions and things like that. I wish I could participate in the broader chat as a whole. It's just not really, feasible for me to concentrate and think about what I'm saying and say it and be reading at the same time and stuff like that. So it just doesn't work. But I really do enjoy, those of you who are able to send the super chat so they get to my attention. And it is very important to me to try to acknowledge all of those. So thank you very much for all your support. Sleeping in tomorrow for that extra hour. I can't wait. Very much looking forward to it. So with that, guys, I'm very eager to see what Monday brings. I hope that the defense, after just this beatdown, this unwarranted beatdown that they've taken from this judge unfairly, improperly, all of these cheap shots. I know that this has been exhausting for them. I really do hope that they're able to get recharged over the weekend, re-strategize, and recommit, steel themselves once again for battle, because there's still plenty of trial to go. So with that, guys, I'm going to enjoy my day off, and I will look forward to seeing you back Monday evening when we come back with the update on day 18. So thank you again very much for joining me. Thank you, mods. Thank you, line setters. Thank you for all of you supporting the channel. And I will look forward to seeing you Monday.